All right, that was the wrong countdown because that one's way too long. So I'm just gonna remove that one from my branding thing because man, that I've
All
got another
30
one.
seconds. It's so long.
Yeah, I've got a 10-second one that is way better. So, all right. Hey, folks, welcome to Role of Law. We've got Mike Bloke on the Range and Uncivil Law here to talk about. Yeah, what do we describe this? Well, so GWACS, and I know there were some people giving me grief over my pronunciation last time, but seriously, is GWACS any better? You know, GWACS rhymes with ducks, but GWACS sounds like a product you get at sort of the CD sex shop. So I don't know who was involved in their branding, but whoever it was should probably be swatted with a rolled up newspaper and told not to do that anymore. Like we need an actual marketing
That can break
person
up the Mighty Ducks. GWACS. 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 Yeah?
Yeah, this is. But regardless, they are suing KE Arms, and for a whole bunch of things, some of which have been dropped, but they started out suing them for a whole pile of stuff. So in a previous video, I covered how part of their motivation for suing appears to be that they just want to stop production of an AR lower, because one of the people involved, Mr. Reed Oppenheimer, which, I mean, come on, that's an amazing name for. There's a lot of really weird names for this. This is kind of like if you were trying to make a movie, people would be saying these names are a little bit too on point. Mr. Reed Oppenheimer is sort of our behind the scenes trying to prevent AR-15 lowers from being made because he doesn't like guns. And the other sort of major figure that we've got is a Judson Gudgel, which I apologize to all the Judsons out there, but that's not a name that's super in fashion now for a whole lot of reasons. It's like if you want to name your kid such that people are going to hear banjo music when they hear the name, that is the kind of name you go with. So, all right. So let's have a look at this lawsuit because they're suing KE Arms, and KE Arms is sort of a one of the major figures involved in this is Carl from In Range TV, who is known to most of the gun community and is he puts on, just as full disclosure, he puts on the brutality events that I go to. I met him really briefly. Like I got a picture and said, "Hey, thanks for hosting these," and he sort of went, "Cool." And then he had other things to do because he's running an event. So that's pretty much the extent of sort of the connection there. I see. I don't like guns. Invests in a firearms company. Lol. What? Yes, that's exactly what we're looking at here. So I did that previous video. They actually did something really interesting, which was that they said, we want to ask for a gag order on the parties because we don't want them talking about these details, which they then put as an exhibit. So when you really want to keep something quiet, the best way to do it is to put it on as an exhibit in an official filing.
What are the things we're not supposed to talk about? Please tell us more.
Yes. And I mean, I've got a Pacer account, so that wasn't hard to get. I was actually kind of surprised because when I saw the In Range TV videos, I saw the other videos out there going, "Hey, this is what's going on." I was kind of surprised that they were bold enough to put that into a public filing. So, all right. So let's have a look at the complaint here. So we're going to start with the complaint and just go through things so that people know what we're looking at. All right. Let me just pull that up. And we can make this end of it go away. All right. Hopefully everyone can see this. So we've got KE Arms, GWACS Armory. Again, that sounds like such a cheesy product. Against KE Arms, Russell Phagan, Sinistral Shooting Technologies, and Russell Phagan basically is Sinistral Shooting Technologies. That's his company. Brownells, who, if you're in guns, you know what Brownells is, and Sean Nealon. Now, I think Sean Nealon's been cut loose. So I don't know if they're in a jurisdiction where comes now is required language, but I hate that language. So, yeah.
Don't like the comes now with the GWACS.
Yeah. I always describe it as sounding like it's, from an 18th century porno, but now, so an Oklahoma limited liability company, by and through its attorneys of record, James E. Weger and Ted J.B. Bogan of the law firm of Jones, Gotcher, and Bogan. This is going to be important. Remember this law firm, because there's some interesting choices being made around the law firms, and we'll have to talk about that as we go. All right, and they complain against the people I just mentioned. So, parties, jurisdiction, and venue. This is boring stuff in a lawsuit, folks, but you really need to, you have to include it when you're filing a suit, right? You have to say, this is why the court can hear our matter, and this is who we are. So, it's not super important, but basically, they're going to talk about how this should be heard in Oklahoma. There was a dispute over where this would ultimately end up being heard, but that's not the most important part of this, or the most interesting part of this lawsuit. All right, so skipping over,
you've already skipped over something that's worth looking at.
The
first bit of twisting there, you see, into an asset purchase and sale agreement. Hereinafter, quotes, something completely different.
So yes, entered into an asset purchase and sale agreement. Hereinafter, the IP purchase agreement. Yes, okay. That'll be an interesting sort of point on all of that. Yeah. Because language is important in this. You can sort of do a lot of twisting with language. And asset purchase and sale agreement, well, is it an IP purchase agreement? That'll be something we have a look at here. Oh, so, yeah, I'm not entirely sure if Nealon is out. I saw a request to dismiss him, but I don't know if that was granted or not. I'd have to follow up here, but he may still be involved in all this. Amount in controversy in this matter exceeds $75,000, which is that they're asking for more than that. That's important for which court it ends up in. All right, so factual allegations. Here's where the actual meat of what they're saying happened. Now, keep in mind, this is the complaint. So if you find yourself reading the complaint and going, ooh, it sounds like one side should win, well, if it's the people who wrote the complaint, that's expected.
They're doing their
because, job. Yeah, I mean, you don't write a complaint to say, hey, we lost, we should lose this.
Yeah.
But if you ever read the complaint and you think that the defense should win,
yeah,
it's a very bad complaint. So I want to just sort of specify that here because these are the allegations from GWACS. All right. So plaintiff incorporates and realleges the allegations contained in paragraphs 1 to 10, which is basically there are various organizations that are located in various places. So the jurisdictional issues. In or around December of 2000, Cavalry, which was owned by Nealon, created a polymer lower receiver for the civilian version of the M16 rifle, commonly referred to as an AR-15. Cavalry's polymer lower receiver was called the CAV-15, and this production was discontinued in February of 2003, so a long time ago. In or around November of 2003, Cavalry began producing CAV-15 polymer lower receivers called the CAV-15 Mark II, so the second iteration, which was a derivative of Cavalry's original CAV-15 designs. In approximately 2009 or 2010, Cavalry and Nealon were investigated by the United States Department of Justice, which is not a great thing. Upon information and belief, on February 18, 2010, Nealon pled guilty to violation of federal firearms laws relating to the unlawful transfer of firearms. There might be some interesting issues about this with respect to GWACS as well, but we can talk about that a little later. Thereafter, Cavalry and Nealon lost their federal firearms license and ceased to be in the firearm business. That tends to happen when you lose your FFL. Defendant Phagan, so Russ Phagan worked there from 2001 to 2010. And in or about April of 2010, Phagan's company, SST, that's Sinistral, purchased the assets and intellectual property relating to the CAB-15 from Cavalry, including but not limited to the Mark I and Mark II molds, toolings, CAD drawings, and all intellectual property relating thereto. Now, this is going to be an interesting point because this is an assertion made by GWACS, but I don't think they ever actually checked to see if SST actually got all of the intellectual property or if they just got the molds, toolings, and drawings. Because there's more intellectual property.
Gudgel admits this in his deposition, that they never actually did any due diligence to check what Russ bought.
And yeah, this is the kind of thing, like when you're actually trying to buy something from somebody, you should check that they originally own it. So if I want to buy a car, one of the things I want to know is, if I'm going, hey, Kurt, I'd like to buy this car from you, this car you're driving around, can we maybe determine that you actually own this car? That would be a thing that I'd want to know right from the outset, because if Kurt doesn't own the car that he's selling me, then he's not going to be able to sell me the car. And there might actually be, the car is a worse example of this than IP law, because there might be something of like bona fide purchaser for value that can convey the car to me anyway, and Kurt might be in trouble, but I might still end up with the car. With IP, it's not, you can't create IP from nothing that doesn't exist just by purporting to sell it. So with intellectual property, this is incredibly important that you make sure that the other side actually owns this stuff, because otherwise you run the risk of buying something that doesn't exist. But I mean, we're going to get to, like, they're going to allege that there was some fraud involved in this, and we're going to get to how I don't think that's going to hold up at all, because their purchasing agreement is real bad. Real bad. And their failure to do like the diligence on this really is something that implicates counsel. The people who were drafting up that agreement, because this is the kind of thing you want to do properly. Kurt, if you're buying a company and you want to get patents, you'd want to like name those patents, right, in the purchasing agreement.
That'd probably be a pretty good thing to do. Yeah.
And not just
particular importance. I might want to name specific ones because I'm really concerned about those. If they go to the heart of the company, probably, or at least put them into attachment or something.
Yeah, if it's a company that makes, a particular engine part and they've got a patent on like a fuel injection system that no one else makes, you'd name that particular patent probably by like this number.
Yeah, that'd be a great way to do it.
Yeah, because otherwise, if you just say, and you'd certainly check that they actually own that patent, like that they're not just producing stuff without actually having the patent. Correct?
Which does happen.
Yeah. I mean, so you got to check this stuff. This is like, I'm not a patent guy. But this is basic due diligence. This is like, hey, if you're buying a house, check that they actually own the house that they're selling you, this kind of stuff. So this is giving me a headache when we sort of look at this. So Phagan thereafter attempted to obtain his own FFL to produce firearms, including the CAB-15 lowers. However, he withdrew his request for the FFL prior to the ATF's approval because he believed he would not be able to obtain his FFL due to his prior relationship with Cavalry, Nealon, and another individual indicted along with Nealon. This happens with bureaucrats, is that if you happen to be standing too close to somebody who gets into legal trouble, you now have legal trouble. So I don't think there's been any suggestion that Phagan did anything wrong in any fashion, but you're just too close. In or around September of 2011, Phagan and SST advertised the CAB-15 polymer AR-15 lower receiver molds and IP for sale. On November 22nd, 2011, Sinistral entered into the IP purchase agreement. Again, this is their framing of it, but it's that asset purchase agreement that they've decided. I mean, this is a little bit of weaseling, because we see they call it an IP purchase agreement now, and when we go back up, it's the asset purchase and sales agreement. Normally, when you're doing the hereinafter referred to as a different thing, you're usually using a shorter phrase. This is a little shorter, but it's not a lot shorter. So I kind of shake my head a little bit when they're just doing it to sort of reframe things. And Kurt, I see some people in the chat are asking if you can turn your mic up just a touch. So, all right. So the purchase and sale included the CAD drawings, design prints.
That's better.
Coming in good for me. Hopefully the chat will confirm there. The molds and tooling for the Mark II. Plaintiff further purchased the production equipment, takedown pins and specifications, serial number tags, and other miscellaneous tools and equipment for the manufacture of CAB 15 lowers. A copy of the IP purchase agreement is attached hereto as Exhibit 1. We'll have a look at that as we go. But again, IP purchase agreement is not a great way to look at that there. Pursuant to the agreement, Sinistral represented that it owned sole exclusive good and merchantable title to the assets, free and clear of all pledges, claims, liens, restrictions, security interests, charges, or other encumbrances, which applies here to the CAD drawings, the molds and toolings, these serial number tags, and other stuff. They're actually very unspecific about the IP, as we'll see. And they paid $120,000, which is a really good deal when you think about all of the stuff they get on this. So, yeah. And I see, don't be a punk, buy a, so, what would Stoner do 2020 if you don't own one already? Yes, go check out their page. They've got a whole bunch of stuff for sale. And, yeah. By all accounts, they are excellent rifles. So thereafter, yes, they're great. Plaintiff exclusively produced the CAB 15 polymer lowers for AR-15 rifles. CAB 15 polymer lowers are unique from other AR-15 lower receivers in that they, among other things, now when they say unique here, unique is going to be real generous. That they are a polymer instead of aluminum monolithic lower receiver with a permanent buttstock attached. I don't think that's unique at all. Are stronger than other polymer designs. Well, you just said that that's unique, and now you're saying that there's other designs, so maybe not so much. Are lighter than their aluminum counterparts. That's just the nature of being polymer. Yep.
Yeah.
And can be manufactured faster than aluminum lower receivers.
Also,
again,
the nature of polymer.
Yes. So
yeah.
So we're unique except for basically every AR manufactured in demand.
Yeah.
Yeah.
And what's interesting that they're doing on 23.23 is that they're trying to make it sound as if they're doing that it's a one-to-one copy of the Cav Mark II, which it really, really isn't.
No. So
well, I mean, it would be a little bit strange for it to be the one-to-one copy because it's called the Mark II. So, I mean, if it were a one-to-one copy, I think that would be a deceptive trade practice.
So then they've got the honor about February 25th. After Sinistral sold the IP to Plaintiff, Phagan went to work for Plaintiff as a sales representative selling Plaintiff's CAB 15 polymer lowers. Okay. And then in 2015, he went to work at KE Arms. So in 2015, they entered into the KE Arms NDA, a copy of which is attached to hereto as Exhibit 2. We'll have a look at that too. At the time of the NDA, KA was selling triggers for use in Plaintiff's CAB 15 lowers, and KA and Plaintiff were working together as the products they manufactured were often sold together. Makes sense? Pursuant to the NDA, they agreed to neither use nor disclose Plaintiff's proprietary information, including but not limited to trade secrets, know-how, data, operations, records, finances, assets, technology, software, research, inventions, future products, and business development plans. KA also manufactured lower receivers for AR-15 rifles, but KA's receivers were aluminum and were unlike Plaintiff's CAB 15 monolithic polymer receivers with a permanently attached buttstock.
All right, I'm just gonna have to stop you on one thing right away because, like, trade secret, okay, trade secret only applies as long as the thing is secret, right? So the formula to Coca-Cola, for example, the
Yeah.
problem with something like an AR lower is that you can look at it and you can see it. So I can just go out and buy one, and then I have one to look at. And if I can reverse engineer it, which it's an AR lower made of polymer, so how hard can it be? Then
Yeah.
not so much in your trade secret. So.
So just for the benefit of the chat here, who probably have never dealt with this, there's various ways to protect IP, and like patents are, if you have invented a new kind of padlock that nobody else has come up with, you can patent that, and then you're given the exclusive right to do that for a particular period of time.
20
But
years.
the downside, yeah, and I'm not sure if that's universal across every country or if it varies from country to country, but it's a limited period, and it's spelled out in the law. But the downside is you have to publish the information. You have to tell the world about how you make these padlocks, and then anybody else, eventually, this is going to come into public knowledge, right, and public use. But so sometimes you want to protect things by just keeping them secret. But there's only certain things that you can actually keep secret. And the Coke example is a fantastic one because Coca-Cola is one of the most famous trade secrets out there. And the thing is like, just because you have a can of Coke doesn't mean you necessarily know how to make the actual product. You can, chemically analyze it, but actually making it from that formula is going to be really hard.
Yeah.
So
can I actually interject there, because this is this comes up in the discussion of the internal structure of the receiver. So the chemical composition of a can of Coke, that is public knowledge. The first time they sold Coke, they disclosed its chemical composition because it's analyzable. How they get to that composition, so the recipe, that's the trade secret. And it's not necessarily an obvious distinction, but basically, if you can get to it by analyzing it, by whatever means, it's disclosed. If you can't, it's secret.
Yeah. And the downside, as we've been talking about, the trade secret is that someone can figure it out. If someone can reverse engineer it, there's nothing stopping them from doing so, right? So someone else can produce Coca-Cola. Now, they can produce the product. They can't call it Coca-Cola because that's infringing on their name. They can't use Coca-Cola's designs or marks, for example. But if they want to sell a product that's made exactly the same, assuming that they can figure out how to do that, then they can. Nothing can stop them. So they can reverse engineer it. Now, most companies, even if they could, aren't going to, because a little bit, what's the point? Like if PepsiCo could completely reverse engineer Coke, which I'm sure they could, but why would they bother? Because now we're just selling Coca-Cola, and there's nothing differentiating us. So what's our unique value proposition? There isn't one. So no one bothers because it isn't worth anyone's time because it doesn't make any sense. But if you're making AR-15 lowers and you can just look at it and be like, well, okay, this is what it looks like. Okay, I can design something that looks exactly the same. I can analyze it, make exactly the same chemical manufacturer. It's like, yeah, okay.
Yeah, so when he's talking about like the trade dress and so forth, like this color of red for a beverage product is protected. The Coca-Cola name and also the pattern, all of that is protected. Like they've got a whole lot of so all you could do is make a beverage, but then you're competing with like
Coca-Cola.
Coke bottling. Like that's going to be a difficult proposition to, how are you going to make Coke cheaper than Coca-Cola company does? But yes, with, for anything else, if you're putting a physical object out there, it's really hard to actually have a trade secret about the shape of that object, because any analysis, I've got like a little remote here, and analysis would include taking this thing apart and looking at every component. Anything you can do with the physical object in hand is part of that. So once you sell one object, all of those physical elements of it are not part of the trade secrets. Now, you might be able to have trade secrets relating to that if it takes some sort of secret process to make this object. that is non-obvious. Like, this pocket knife. Let's say this pocket knife can only be forged in, the fires of Mount Doom.
Awesome.
Then that might be a trade secret because no one else knows that. They just think that it's this physical object, but I've got this secret knowledge about it. So their trade secret claims here are going to get real suspect and real hilarious. So, and I see somebody saying, what about software piracy? If it can be reverse engineered, it loses copyright. Copyright is different. Copyright. So ways of doing things might be able to be covered by software patents, but the actual specific expression of doing it is what's covered by the copyright. But you may, for instance, be able to do the same thing via your own design on that.
Yeah. So this because this goes to my field, which I was doing for 15 years in software patents, right? So if what you patent is the way it does things, right? Not the actual code, right? The actual code is covered by copyright. The way it does things, the methodology of it is patents. So if you can reverse engineer the way software works, if you can write a piece of code that does the exact same thing as another piece of code, then fine. But if you've done it without looking at the original, there's no copyright infringement. Even if somehow you managed to write the same code twice, incidentally, if you could truly do it without looking at it, if you can create it completely independently, there's no infringement. So in the particular expression, but if it does the same thing as a different piece of code, that's where patent law comes into play. Patent law protects the use of the thing. It protects the useful arts. Copyright is not useful in that sense. It is not. It doesn't have utility. One of the ways I try to, it's the idea expression dichotomy in copyright. For those of you who are familiar with it, one of the ways I try to express this is by saying, for example, anyone can write a book about a group of young people who go off to a wizarding school and have adventures, but only J.K. Rowling can write Harry Potter, and that's sort of the distinction. It's like, there's Harry Potter is a particular expression of a genre itself is not protected. So hopefully it makes some sense. Maybe I just confused everybody.
No, I mean, I think it's a good aspect. And the other thing is when you talk about if you could write the same software, if you're looking at something like Hello World, just like the really base, I'm sure Hello World has been written the same exact character for character way more than once.
Yeah.
Just by people who are just trying to figure that out. And I see one person noting trade secret is nice because it doesn't have an expiration. It expires as soon as the secret is out. But otherwise you can have your trade secrets for however long.
Yep. Exactly. Trade secrets can last. Trade secrets last as long as the secret is maintained.
And then you get into fun times when a competitor works out what you've been doing more or less, and then patents it, and you end up in a right of continued use situation. That's always fun when that happens. They can block you from doing your own thing because you didn't disclose it to the public, so there was no novelty barrier to someone else patenting the same process that they've come up with independently. But we're going down the rabbit hole a bit here.
Depends. I mean, if guy A was selling it, that would work as a barrier to the other guy patenting it because you have to be an original inventor. But that gets into the nitty gritty of a whole bunch of things.
Yeah, and in Europe, we just have this absolute. We don't have this whole first inventor thing. Okay. So you can actually quite easily end up in the situation where someone else's patent they patent the process that you've been using internally, but keeping as a trade secret, and then blocking you, and then you have to claim a right of continued use. But then you're heavily limited in geographic and quantity.
Fun, exciting.
And it's really fun and exciting the way that works here.
And I see somebody noting supporting just because Mike and Kurt are on the same stream. I never thought I'd see the day. This is kind of an interesting combination of circumstances here. All right, so yes, so we've got all right. KA also manufactured lower receivers for AR-15 rifles, but they were aluminum, and unlike Cab 15 monolithic polymer receivers with a permanently unattached buttstock. Unbeknownst to plaintiff, on or about February 25th, 2016, KA purchased 2 boxes of assorted blueprints and 1 thumb drive of assorted CAD/CAM files from Neelan in exchange for $1,000 in cash and $9,000 in KA firearms products. And so now my understanding is that this might include a whole lot of stuff that are completely unrelated to this project. So, you're buying an assorted collection of stuff. You don't necessarily know what's in it. And you can infer here that it was not a great value of stuff because it's 10,000 total. Not a whole lot for all that. At the time, Neelan sold the above referenced blueprints, the CAD/CAM files relating to the CAV-15. Neelan, KA, and Phagan knew Neelan did not own the IP to the CAV-15 and that the same had been sold to plaintiff by SST in 2011. And this is kind of a so what, because you can sell the CAD files without owning the IP. If we go back to the Harry Potter example, I don't own the IP to Harry Potter. I don't own a single fragment of that IP. But nevertheless, if I buy, Harry Potter and whichever book, I can then sell that copy on to Kurt. That's not an issue. There's first sale doctrines and all of that stuff. Just if you own a copy of something, you can sell that copy typically. You might have restrictions on software, but there doesn't seem to be any such restrictions here. So, all right. In 2017, InRange TV did an online video on YouTube featuring plaintiff's CAV-15 lower receiver on a fully assembled AR-15 rifle, which sounds like great promotion. Following the InRange TV demonstration, plaintiff's CAV-15 polymer lower receiver gained significant national attention and popularity among gun enthusiasts. Those bastards. All
right, people were excited by the product. Great. Moving on.
I'm just like, this is the worst thing that's ever happened to your company is that somebody has now made it popular. Okay, sure.
Well, damn us. Next time we'll make sure not to make our company's products popular. Damn.
And then by the middle of 2018, plaintiff had sold out of all of its CAV-15 Mark II polymer lowers, which plaintiff disclosed to KEA and Phagan since the parties had entered into the KEA NDA.
Oh my God, they sold out. Oh wow,
they
real hardships. They will have to make some more.
Well, we're going to get into that too. KEA and Phagan had been inquiring about future production of the CAV-15 lowers because KEA was selling triggers to go with plaintiff's lower receivers. Hey, it'd be great if you guys made more of these things. In or around June of 2018, after the KEA NDA was signed, plaintiff disclosed to KEA that the CAV-15 Mark II molds were old and getting worn, causing additional post-production work to be required, and that plaintiff was planning to discontinue production of the Mark II version of the CAV-15 lowers to begin efforts to produce next-generation CAV-15 lowers, which they would call the Mark III and Mark IV. Okay, so they're going to make a new version. Okay. Plaintiff further disclosed to KEA that it was seeking investors to fund the continued development and production of its improved CAV-15 lowers. Plaintiff also submitted an investment packet to KEA pursuant to the KEA NDA. And they were further aware plaintiff had submitted an investment packet to a large firearm distributor, Brownells, in an effort to secure investment for the future production of plaintiff's CAV-15 lower receivers. The aforementioned investment packet included renderings for the Mark III and Mark IV, as well as internal financial projections for the same. Further, KEA and Phagan were made aware after signing the KEA NDA that Brownells had given a plaintiff a purchase order for approximately 100 units of future generations CAV-15 lowers and provided a letter stating that projected orders
100 units.
But
I mean, that's nothing.
That is nothing. I bought more than 100 units of various things that, and certainly the company didn't think that I was keeping them afloat. But they did say that projected orders would be 8,500 units, which was done in an effort to help.
Brownells is kind of nothing, to be honest, but okay.
Yeah. Brownells is not a small they're not a small player in the firearm market.
No.
And I kind of feel like Brownells can move 8,500 of just about anything in a heartbeat. All right. So the foregoing was done in an effort to help plaintiff secure additional investors. Further, plaintiff, along with Faxon Arms, KA, and Brownells, were working together during the relevant time period to produce a fully assembled firearm, which would include plaintiff's Cap 15 lower receiver, KA's trigger, and Faxon Arms upper and final assembly. Brownells was to utilize its distribution channels to distribute the rifles under Brownells' name. Okay, so they're going to sell some of these things, but it looks like KA was actually the better sales group here for moving these things. Plaintiff protected its IP through the KA NDA, as well as 2 other non-disclosure agreements with Brownells. The first dated May 31st, 2013, attached as Exhibit 4, and the second dated January 24, 2016, attached as Exhibit 5. Hereinafter collectively referred to as the Brownells NDAs. Now, we'll just stop here for a second. Is this considered the best practice for protecting your IP?
No, not really.
I mean, are there other things we might want to do here? Like, copyright or patents or trademark registration or any of that stuff?
If you think that you have anything unique, which I'm doubtful in the first place, which is maybe why we're saying trade secret, because we know we can't get copyright. We know we can't get patent because there's, for something to be patentable, it does have to be unique and non-obvious. Or one of the two, at least. It has to be unique or non-obvious. And it's like copyright does not protect useful arts. Copyright does not apply to something that has utility, which these things seem to have utility. So, okay, copyright's probably out. Patent's probably out because the R15 lower, it's been done a little bit. So we'll just pretend like it's all protected by a trade secret. I think that's I think we're doing it because we don't have any other choice. We'll just pretend it's secret. We'll just say it is.
Yeah. And this is a product that had been on the market for a very, very long time.
Yeah.
By then. So claiming that there's any form of trade secret on that is a brave line to take.
Yeah. I mean, you can't NDA an intellectual property right into existence. It's got to exist previously, and yeah. We're having trouble getting our supplies of mithril in for this project. So, yeah, this is just bizarre. All right. So, from approximately August through December 2018, plaintiff was in discussions with Brownells and KA, who were talking to InRange regarding production of the complete rifles discussed above. And thereafter, InRange was to feature the Cav 15 polymer lower receiver on the fully assembled rifle on InRange's show. So they're still trying to get more, InRange is going, hey, make more of these things. Brownells, pursuant to the Brownells NDA, was also made aware of the condition of plaintiff's Cav 15 molds and plaintiff's future development plans for the Cav 15 receivers. On September 10th, 2018, Brownells asked plaintiff about licensing the use of plaintiff's Mark II molds to produce additional Cav 15 lowers, but plaintiff did not grant a license to Brownells. Okay. Plaintiff was unsuccessful in raising the capital needed for the production of the new Cav 15 lowers, including further development and production of the Mark III and Mark IV derivatives of the Mark II, and was not financially able to meet the production demand required for the proposed deal with Brownells. So that's a bad thing. And when plaintiff was unable to produce the Cav 15 lowers necessary to meet the demand of the market and /or Brownells distribution plan, KA and Brownells colluded to willfully and maliciously misappropriate plaintiff's IP. KA began
by doing what? How?
Well,
they looked at the thing as we'll make our own molds.
Say KA began efforts to produce and market Cav 15 polymer lower receivers using the name Mark III, KE15, and /or KE15 Mark III, the KA polymer lower.
Oh, we want to claim trademark rights over the term Mark III. Oh, okay, that's good.
It was
another
brave one. Yeah.
So
we're the old people know us as the Mark III people. When you say Mark III, you think of our brand instantly. What's your name again, by the way?
this is a really bold claim for a number of reasons. First of all, normally you'd have to actually like do business as the Mark III in order to gain any, and they failed to do that.
No help.
So how is the public supposed to associate the Mark III with a product that never existed? Now, second, if you ask a gun owner, if you go up on the range and you say, hey, I just bought a new Mark III.
Yeah.
I can guarantee you nobody is thinking Cav arms. They're thinking Ruger. They might be thinking, Browning, but nobody's thinking cavalry. So, yeah. Mark III is super generic. It's super firearm companies have been describing their products as the Mark I, Mark II, Mark III, etc. for longer than I've been alive, certainly. So this is a really bold claim when they're talking about the name. Willfully and maliciously misappropriate plaintiff's IP. Well, let's see if they actually get us to even the misappropriation, let alone the willfully and maliciously, which normally this is a little bit of overly flowery language here. All right. Subsequently, Brownells presented a prototype firearm at a large gun convention. According to Brownells' representative, the prototype included a KA polymer lower based upon the CAV-15 design. Now, which design? Was it based on the Mark I? Was it based on, and how was it based on it? So KA and Brownells moved forward with the CAV-15 project using plaintiff's IP without plaintiff's knowledge or consent. Okay, how?
I'm not sold.
Yeah, I mean, normally you'd want to just good drafting on this is normally you want to spell out exactly how they do it, and I mean, ideally you'd want something like, here's our design for the Mark III, which was only ever disclosed to anybody versus via this NDA, and look how it's exactly the same, and here are the unique features that exist on no other firearm.
That'd be great.
Those are the things I would like to include. And when you don't see that in the drafting, it kind of tells you that probably isn't the case.
It's that we didn't include it because we couldn't, because it would be lies.
It's like if you have somebody who's run over, if they're in a crosswalk walking on the walk sign, you put that into your complaint. And if you don't put that in the complaint, you can reasonably infer that those things weren't the case because you would have put that in there. So I have to be honest. If I hear Mark III, I'm thinking of Iron Man. There's so many products out there that are described as Mark III. Enough so that Iron Man is actually kind of a nod to the practice in the gun, like in the weapons manufacturing industry, of naming things Mark I and Mark II, Mark III. So you're not wrong here. You're exactly right. So yeah, it's and I see Benelli may have something to say about the yeah. So GWACS has a M4 Model 2. Does that mean Colt can sue them too? Yes. If you actually accept their logic here, they're opening themselves up to lawsuits from
everybody.
Ruger, Colt. This is not great. All right. So further, KA and Brownells marketed and displayed the KA polymer lower online and in catalogs as the Mark III. Okay, you're going to need to show you've actually got rights over that name, which is a really bold claim. All right, first cause of action. So they start off, and thank God that they're doing this, incorporates and realleges the allegations contained in paragraph numbers 1 to 51 above. Because if they didn't repeat that, then, oh my God, we would just die. All right. So, pursuant to the KA-NDA, proprietary information means any information disclosed by one party to the other that is marked proprietary or that relates to the business of the discloser or the discloser's affiliates, including without limitation trade secrets, know-how, data, operations, records, finances, assets, technology, software, research, inventions, future products, customer information, or business development plans.
I take some exception to that. Merely marking it, stamping it proprietary makes it proprietary. It's like just because it has a stamp of confidentiality makes it true. I don't think that's quite how it works.
Well, there's another really fun aspect to this, which is they didn't actually, when I was looking over, so I managed to get some of the deposition details and looking over some of that. They didn't actually use proprietary as a stamp on anything. They were using confidential.
So proprietary is everything marked proprietary, but nothing was marked proprietary, so therefore nothing's proprietary. So your entire cause of action is done. Well, that was easy.
Yeah, this is why you hire good lawyers. Oop, and I just kicked out my audio here, so there we go. If you're going to use specific language in a contract, like we will mark things as proprietary to indicate that they are our secrets,
you might want to do that.
You want to do that specific thing. Like confidential is not a good substitute. Secret is not a good substitute. You got to use the word you used. These things.
Yeah. At least in patent law, we call that being your own lexicographer. It's like if you want to use your own terminology, go nuts. But then you actually have to, do that. So
yeah. Once you've defined the word, you got to use that word. All right. So further, the KANDA provides the receiving party and its personnel shall use proprietary information only for the purpose set forth in paragraph 1 hereof, and shall not use or exploit such proprietary information for its own benefit or the benefit of another without prior written consent of the disclosing party. KA breached the KANDA by using, disclosing, and exploiting plaintiff's proprietary information, including but not limited to plaintiff's IP, trade secrets, know-how, data, operations, finances, technology, software, research, inventions, future product information, and business development plans. This is a bold assertion that they don't explain at all. Like, which IP did they actually use? Like, how did they do it? You're going to want to actually say something like, hey, here is the model. We know that they use this particular thing in this particular way. Now, I mean, this is the complaint. Hopefully they're going to, get to this by, they won't get to this. Like this, you'd want to at least show similarities between the product that KA is selling and the one that they were developing, but they don't at all. So, yeah. Okay.
I also like the idea that there was somehow software included.
Yeah.
Yeah.
We haven't heard anything about software at all. So, pursuant to the NDA, plaintiff is entitled to an injunction against KA to prohibit KA from the threatened or actual unauthorized use or disclosure of plaintiff's IP or other proprietary information, and they've suffered damages in excess of $75,000, together with punitive damages, interest, courts, costs, and attorney's fees. Now, the reason why they're saying $75,000 here is that they want damages much higher than that. This is important as a threshold for the court. So that's why they're saying more than $75,000 it triggers certain court thresholds here. I see Just Me saying, I'm so glad to see Kurt and Runkle looking at this case. Also, Mike is not chopped liver here. It seems to me to be a nuisance case just to a small company or tied up in court till it's just not worth making their product. Yeah, this seems like this feels to me like a bullying lawsuit rather than one that's got a lot of merit to it.
If there is anything here, it's not well pled. I mean, it's very conclusory, and they don't really walk me through any details that would let me draw the kinds of conclusions they're asking for. They're just asking me to accept truisms, which I find annoying. So if there's any merit to this at all, it could be better drafted.
And I see Keanu Samis, thank you as well for the super chat, saying hi, guys, and the little Canadian flag there. So, yeah, typically by the time you get to these kinds of, in good drafting, by the time you get to these kinds of conclusory statements, you want the reader to have already concluded that because you've told them the basics of it. You know, if you're talking about like a personal injury thing, you know, you talk about, okay, the kid was crossing the crosswalk. They had the green light at the crosswalk. They were struck. There was no attempt to brake by the oncoming, afterwards, the police tested the driver and found that their blood alcohol was sky high. And then you can say, listen, this is negligence. And by the time you get to this is negligence, you've already concluded it's negligence because it's like clear day, crosswalk, they had the walk sign, the driver was we're already there. You can't just kind of leave all that out and say they hit the person and it was negligence because we're not there yet. So this is like bad drafting in a way that should make
it's not the worst I've seen. It's just not good. I mean, on a scale of 1 to 10, it's like a 3. It's not like I want to tear my hair out, but it's like it just leaves a lot to be desired.
And I see, could software include things like CNC programs or molding machine programs? I don't think there's any allegation that they had any such thing. Just CNC like CAD files. So, but
which I don't really think it's software. A CAD file is not really software. I mean,
yeah, although lawyers often don't know, and juries may not know either. So fair enough. You would include that just to be sure there. And I think that's a decent question. Like that is a good thing to look at here. So, second cause of action: misappropriation of trade secrets against KA, Phagan, and Nealon. So they're reincorporating everything above. They're going to do that for each new cause of action. KA and Phagan developed the KA polymer lower, which is a product used or intended to be used in interstate commerce. KA and Phagan.
Everything's interstate commerce, so get out of here.
Yeah. Interstate commerce in the States has been interpreted so broadly as like
not interstate, not commerce. Wickard v. Milburn. Yeah.
Yeah. If you sell something entirely like within your neighborhood, this might diminish demand in another state for that product. Therefore, it's interstate commerce. If you have a lemonade stand, just at the corner, that's probably interstate commerce because people might import less lemonade from the next state over because you satisfied their lemonade demand.
Wasn't there even a case of someone doing something for their own personal use, and that back in the NEP era, it was like a farmer growing corn to feed his
That's
own
Wickard v.
crops.
Filburn. Yeah, it was that's Wickard v. Filburn, one of my least favorite cases of all time. Yeah, growing wheat for his own use, for his own consumption, by his own animals on his own farm is somehow interstate commerce, even though it's neither interstate nor commerce. But yeah, never mind. Yeah.
And this is basically, at this point, interstate commerce is almost like a legal fiction, just intended to allow the law to do all sorts of things that maybe the law shouldn't be able to do. But yeah. All right, carrying on here. So, knowingly using plaintiff's IP and trade secrets without plaintiff's consent and to plaintiff's detriment. How? Like, what was the process here? You've said that they had access to it and then they developed this product, but there's like a whole bunch of steps here that they didn't cover as to how they actually used it.
Step 1 underpants, step 2 question mark, step 3 profit is not how you want to write a lawsuit.
No. And when you see a lawsuit like this, you should kind of suspect that step 2 doesn't exist. You're going to be stuck with a lot of underpants and not a lot of profit, which I think is where this is headed. But so KA and Phagan stole, misappropriated, and used plaintiff's financial, business, scientific, technical, and economic and engineering information, which plaintiff took reasonable measures to keep secret, and which was not generally known, to develop the KA polymer lower. They assert this, but did it actually happen? Like, tell us how they did this. KA and Phagan obtained plaintiff's trade secrets through information disclosed pursuant to the KA NDA, as well as files and information unlawfully obtained from Neelan in 2016. You haven't even established that you own a trade secret yet.
This was something I saw earlier today in the Gudgel deposition, was that they're claiming that because they bought stuff from Russ, then Neelan had no right to give stuff in his possession to Russ later. It's really pretzel logic. It's like they like something with Russell bound Neelan.
Yeah, that's a very they have a very novel theory of the law on that one. And we'll have to cover the depositions in a future video, because otherwise we're going to be here until Halloween. But yeah, there's a lot of bizarre stuff going on here. And I've got other ideas for Halloween videos. So K.A. Phagan and Neelan's misappropriation of plaintiff's trade secrets was willful and malicious. What are those trade? Like, they haven't even spelled out what these trade secrets are. And you don't want to actually like detail the specifics, because of course trade secret is supposed to be secret, but you want to at least vaguely mention what the secret is. KA's, Phagan's, and Neelan's above reference acts were in violation of 18 USC 1831. Like if Coke was suing somebody over stealing their trade secrets, let's say Pepsi actually has refused to take Coke's recipe in the past, but let's say Pepsi, or some novel upstart company, just so that Pepsi doesn't sue me, some novel upstart company wants to start selling, pop. And so they hire a mole to go and they're going to go and do some industrial espionage at Coke. And they break into these secret vaults, which I understand, like, the recipe is stored in multiple vaults and multiple sites. Like, this would be some Mission Impossible kind of stuff here, but they've got, this Mission Impossible team steals the secret recipe. Well, you'd actually at least want to say that the trade secrets are the recipe. You wouldn't want to put the whole recipe into the filing, because that would be dumb, but you'd say it's the recipe. Right? They haven't actually said what these trade secrets are. Okay, yeah, this is a headache. As a result of KA's, Phagan's, and Neelan's misappropriation of plaintiff's trade secrets, more than $75,000, etc., and they also are asking for exemplary damages, so extra money, as a result of their willful and malicious misappropriation of trade secrets, which they don't even know what they are. Cool. All right, third cause of action, trademark infringement. Now, this one's going to be real fun, because
this gets very fun.
On or about July 6, 2018, plaintiff publicly disclosed on its website that it was finalizing the design of the CAV 15 Mark III and Mark IV and used the foregoing marks to describe its products. Okay. Plaintiff disclosed its intent to produce and market the CAV 15 Mark III and Mark IV to KA and its agent employee Phagan on or before July 9th, 2018. Intent to use a mark and using a mark are very different things. Plaintiff used the Mark III mark on Facebook on January 10th, 2019. Now the question is, did they sell a product, or did they just describe a product?
They weren't even going as far as offering for sale.
It was just. This is just they're saying, we are going to be making a thing, but we aren't making the thing yet. So,
and 72, I'm confused because they called it CAV 15 lookalike. That confuses me, because isn't part of the problem that you were saying that it is the CAV 15, that they basically hijacked your thing, and now you're saying it's a lookalike. But you can produce a product that looks like another product, unless there's some sort of intellectual property protection, which for looking like something, not really. No, especially since everyone can see it.
There's literally nothing that would stop anyone reverse engineering a CAV 15 Mark II lower 1-to-1. Literally nothing.
Correct. because it's a useful article, which would be patent law. And they don't have a patent, so that means anyone can do it. So go nuts.
Yep.
Yeah, so they marketed the polymer lower, which is a Cav. The other thing is, like, Cav 15 look alike. AR-15s kind of look alike a lot.
AR-15 lowers kind of look the same because, form dictated by function.
It usually takes like an expert. If in court you want to show that something, like let's say you've got a video where somebody is walking through with a rifle. If I want to show that that's an AR-15, that takes an expert witness, because it might be something that just looks like an AR-15. There's lots of guns that look very similar to the AR-15 but aren't an AR-15. If I wanted to show that it was a specific lower, that's going to take a very distinctive, like that's going to take some real expertise. Because, and I see here Kentucky Fried Chicken, the secret herbs and spices, is that a trade secret or a recipe?
It's both a trade secret and a recipe.
Yeah.
Yeah, it's a secret and a recipe. But again, same thing. If you can figure out the herbs and spices that they use and you can manufacture it yourself, you can't use their brand name, you can't use their colors, but you can make a product that tastes exactly the same. If you can, go nuts.
Yeah. You could,
and there are all kinds of websites that give knockoff and replica recipes for all kinds of products that you can buy at stores to varying degrees of success, and they're all legal. So that's fine.
I know a guy who works at a food lab, and one of the services they offer is like, let's say you've got a product like a spice mix that is discontinued and you can't get that spice mix anymore. Well, you can send them a sample and they'll make you up a new batch and you could sell it as your own stuff. You just can't say, hey, we've replicated this previous brand, because that would be, potentially a trademark violation. But yeah, just calling it a lookalike this is the kind of thing that might sway a jury that's never handled AR-15s. But if you deal with AR-15s, this is such a stupid statement. As the Mark III and MK3, after plaintiffs used the Mark III mark to describe the next model of its Cav 15 polymer lower receivers. Now, there's a really interesting thing that they have dropped out on this, which is that in between all of this, from what I understand, like GWACS went out of business and stopped producing anything. So that's a big kind of distinct detail there. So KA and Brownells use of the Mark III and/or MK3 mark has caused confusion or mistake between plaintiffs' Cav 15 lower receivers and the KA polymer lower, and/or creates deception as to an affiliation, connection, or association between KA and plaintiff in relation.
It would have been nice if there was literally any evidence of that at any point in this pleading. That's like it has created deception. Oh, really? It's created confusion. Who was confused?
Apparently, they got an email.
Well, it would have been nice to mention that in your facts. Nice.
Yeah, I suspect they only found it later.
Well, and also one email from one person.
No, exactly.
Like, what you'd want is something a little bulkier than that. Like maybe, hey, we did a study, but also this is also kind of risky because, like, is there confusion between this and Ruger? Are you guys inviting a lawsuit from Ruger, who I think they have the best known Mark III on the market right now? Mm-hmm. So, no, Ruger should not be suing anybody because this would be dumb. So, just wanted to say, Ian from Forgotten Weapons just gave you a shout out. Keep doing a good job, guys.
Excellent.
I've met Ian from Forgotten Weapons a little more than Carl. It was he's sort of. I have a video where I did the one drill, the Casarda drill, which is, if you've never done this, it's fun, but it also sucks because it involves you pick up a kettlebell, you start out by shoot a target, hit the target, ground your rifle, pick up a kettlebell, hurl the kettlebell, and they're not light. They're real heavy. Wherever that lands is your next shooting position. So you move over there and then you reacquire the target, hit the target, and repeat until you've gotten to the designated distance, or more likely, you run out of time. Especially when you've got noodle arms like I have, you run out of time. So I did that, and I'm sort of staggering back exhausted, and I've got a little bit of audio clip from my camera that's tucked in my pocket of Ian from Forgotten Weapons going, "Good shooting out there," or something along those lines. And I'm like, yes. So yeah. So that is sort of the extent of my conversation with him, but he's a great guy. At some previous things, he was out there. If you don't know Ian from Forgotten Weapons or his channel, first of all, you should be following his channel because it's amazing. But, he goes out to these matches and he shoots interesting firearms because that's kind of his thing. And so he's often there, and he's often like letting people handle these unusual firearms that he's brought, which is a super nice thing to do. So yeah, he's a great guy. But I see K-Drill Life. Yes, but it hurts. It's one of those things where I'm like, I enjoy it and I'm glad I did it afterwards, but I also, it hurts while you're doing it and it hurts for a while afterwards. So
it's type 2 fun.
Yes, I recommend people try it, but it's one of those things. It's like eating spicy things. It's like, I don't know why I enjoy this, but I do. So specifically, KA's polymer lower with the name Mark 3 or Mark MK3 is likely to and has caused market confusion, misleading the public to believe KA's polymers lower is a CAV 15 lower or is otherwise associated with plaintiff's lower receivers.
I mean, that's
Again,
it's the conclusion in a trademark case, but we haven't done any of the work to actually get there. Even if it was a registered trademark, let alone an unregistered trademark. It's just like, yes, you've said the magic incantation at the end of a proper set of arguments, but it was just like skip to the end.
And the other thing is, so the best thing for a trademark is to register it and have that as your trademark, right? That is sort of the gold standard. However, you can have a mark that's an unregistered mark that's in use, especially, if people recognize your company and so forth. But you want it to be at least a little bit distinctive, something where people can know that it's your product. And Mark III is super generic. Like, this is super. Now, if they'd said we're selling a CAV 15 Mark III, I think this would be a great argument. But they would have said that in their pleadings if that had ever happened.
I know the Swiss office is particularly strict on these things, but I suspect if someone tried to register Mark III in Switzerland, it would be refused purely for being generic, for meaning simply the third in a series.
Yeah, yep. I don't think you could apply for a trademark for Mark III.
You would have to, at bare minimum, you would have to show that it has become distinctive. You would have to show that a sufficiently wide portion of the public recognizes Mark III as referring to your brand as opposed to something else. And as Ian has pointed out already, I think that Ruger's got you covered on that one. You're going to have a tough time. So you're going to have a really tough time showing the requisite distinctiveness.
Yeah. And you also, you also need to actually use it in commerce.
That would help a lot.
Like, that's
kind of like step one.
Step one, sell one product called that. One. But they haven't got there. So
the trademark on a mark that we haven't registered and we're not even using in commerce. This is a whole new world of possibilities.
At this point, they're basically, claiming intellectual property and like, I had an idea in my head and I didn't tell anybody. We're like one step away from that. So, yeah.
And your
So now
idea was to call it Mark III? That was your genius plan? You couldn't think of anything better? Is that what you want me to believe? Okay. So you're an uncreative on top of everything else.
So now they want injunctive relief to stop
No.
them from using Mark III, which,
No. You can't have that.
okay, no. Plus damages for unjust enrichment.
No.
Now, this one's interesting because unjust enrichment, of course, one of the sort of usual remedies for that is disgorgement. You guys got profit that you shouldn't have had, so we want that profit.
Yep.
So, yeah, that's a little bit of kind of piracy going on here. Plus dilution of value of their mark. What is the value of a mark you've never used?
Yeah. The theoretical value of the mark of our product that didn't actually exist.
Like the Coca-Cola trademark?
Very valuable.
Huge money. Like if somebody said to me, hey, would you like $1 million or the Coca-Cola trademark? I would take the Coca-Cola trademark in a hot second. Because it's worth way more than the $1 million. I might have a little more trouble selling it, but way more.
I think of one company in Atlanta that might be interested.
Yeah, I suspect that they would be very very keen to get that back if somehow it ended up in my. But like Mark III, no, I don't think that's. I guess if you could trademark Mark III, it'd be very valuable, but that would be a very. I don't see it. All right. Trade dress infringement against KA. Now, trade dress is interesting. Maybe, what do you guys want to handle trade dress, or should I jump into sort of?
I think the easiest way the easiest way to describe trade dress is by chain restaurants. Like if you go into any chain restaurant, you know that you're in that chain restaurant because it has a particular aesthetic to it. And different chain restaurants have different aesthetics to them. So I don't know what your chain restaurants in Europe are, but if you walked into, for example, an Applebee's versus a Chili's versus an Outback Steakhouse versus a McDonald's versus a Wendy's versus a Subway versus an Olive Garden, right? Versus whatever, right? All those stores have a particular look to it. And so trade dress is best described as the overall look and theming of a restaurant that distinguishes it as that restaurant without you ever reading the restaurant's name. If you couldn't read, you would still recognize the restaurant as the restaurant because of the overall aesthetic.
Yeah. So, and I mean, you could make a game of this. Like, here's a picture of the inside of a restaurant, and people would be able to tell you, like, oh, this is a Chili's versus this is, because. But I mean, you can have trade dress and other stuff. Like, hey, the basic fundamental concept of a lamp, you can't. You won't have trade dress over its lampness. But stuff like the shape of it, if you have a particular shape, maybe.
Yeah. The leg lamp from A Christmas Story.
But so this is what they're saying, is that the shape of it in terms of not. Now, importantly, you can't, get trade dress on functional elements because functional elements get really. Functional elements have this special place in law because basically ages ago, smarter people than any of us here realized that, it's very important that we be able to do things as a society and that we not limit people, that we not end up giving somebody a right to some way of doing something improperly. And so anytime you're trying to sort of finagle one IP right into a way of doing something, you're either getting a patent or you're probably doing law wrong. Yeah. If you are saying like, let's say you've got a thresher, a machine for harvesting grain. And if you say the shape of the blade on this machine is our trade dress,
no,
they're almost certainly going to say no, because the shape of the blade is going to be a functional element. You can't use that to gain that kind of right. Right. Coca-Cola would not say the taste of Coke.
Correct.
is
it's functional. It's functional as the Coca-Cola. The product is the way it tastes. And so and it all depends on the nature of the product. For example, Harley Davidson at one point tried to get trademark protection for the sound of its engines. Couldn't do it because it's a result of the way the engine is designed, which is protected by patent, because anyone can produce that engine. And so it's like, well, you can't get the sound because it's unique. It's a result of the functionality of the engine. But so it only extends to things that have non-functional aspects.
There's this side of the Atlantic where we don't have trade dress. People do all sorts of exciting things with 3D trademarks. That's kind of like the cutting edge. And Apple managed to get I think it was a community trademark through on basically what in the US is the trade dress of an Apple store. And that sort of went right up, and they proved it was distinctive, so that people would walk in and know it was an Apple store. And the other one was Lego filed a 3D trademark to the bricks, and that was granted, and they lost it eventually in a court case because it was proved that the bit they were claiming was aesthetically distinct was necessary for the function.
Right.
So it got zapped.
Yeah, and so that's a really big thing. And when you're talking about a firearm, you're going to have a really hard time showing like non-functional elements because guns are really streamlined. There's not a whole lot of room for non-functional bits. And
well, that's a bit of an overstatement. I mean, there's a lot of guns that are very fancy and sort of their ornamentation, and which you could actually have a valid copyright interest in, particularly handcrafted barrels. And some people do some really interesting stuff with jewelry and stuff like that are very expensive, but
or skeletonizing actions, handguards, things like that in a particular artistic design.
Yeah,
that's about the only way I can think of it.
There's possibilities,
really.
But in terms of things like the basic shape, a lot of that's functional because it's ergonomic, if nothing else, right? It's, that's a functional element is the ergonomics of it. So if you're saying, hey, we cut out this particular piece here, well, why did you do that? Oh, well, because it makes it easier to access this particular control. This makes it easier to operate the safety. This makes it easier to operate the mag release. But yeah, the examples like engraved revolver cylinders, yes, absolutely. Like that's a place where you could have trade dress. And I seeing Tank Rat, thank you for the very generous super chat there. Laughing my ass off at Mark III or MK3 or any MK number has been used on AC, tanks, automobiles, and other commercial or military products since before World War II. Yeah. When you want to sort of claim an intellectual property right in a practice, that practice should not predate your company.
Yeah. Or just the use of language.
Details.
Yeah.
All right. So trade dress infringement. Again, they're reincorporating everything they said above, which we appreciate because otherwise this would be...
We would have forgotten everything, which was pretty forgettable. So, I mean, there's fair that's there.
Well, it's just a lot of bare assertions. The overall appearance of the KA polymer lower and the unique combination of non-functional features infringes upon plaintiff's trade dress rights pursuant to... Okay, great. Which unique combination of non-functional features? Overall appearance includes a monolithic polymer lower receiver, functional, with a permanently attached buttstock, functional, which is different in appearance than other AR-15 lower receivers. How?
Is it?
Yeah, including other AR-15 polymer receivers. How? But looks like a CAV-15 lower receiver. How? Like which parts?
This would be a place, by the way, where pictures would be nice to throw them in and show. You could like have them side by side, and you could have circles and lines that would show the important details about things.
This is what you'd expect. Like attached as exhibit whatever are the pictures, that illustrate the side by side comparison, as well as like 15 different other AR-15 monolithic polymer lowers to show how they're all different. Right?
That'd be nice.
But they don't do any of that. They're just like, we're saying it's the same because we say it's the same because trust us. And the thing about pleadings is never trust the pleadings. Like you trust the facts, but not what the lawyer says about them.
Yeah. Mere conclusory statements are not going to get you past the door. We'll believe your facts, but not your
but
conclusions.
you gotta bring some facts, not the conclusions, because the conclusions are where they're going to stretch. So, yeah. KA's violation of plaintiff's trade dress rights is likely to cause confusion or mistake, and /or is misleading or deceptive as to its affiliation with plaintiff and /or the CAV 15. How? This is another conclusory statement. Plaintiff's infringement upon plaintiff's trade dress is injurious to plaintiffs. Okay, this is just bad drafting because they should be saying KA's infringement. This is just an oops. Is injurious to plaintiff and will dilute plaintiff's market share for monolithic polymer receivers. You're out of business in this market before this is filed. So your market share was 0. It's going to remain 0.
Not sure it can get much lower.
Yeah. Are they saying that the market is going to actually somehow start stealing receivers from GWACS? And /or its ability to market plaintiff's IP for future sale or licensing. Well, they'd already failed at that. So, cool. Pursuant to law, plaintiff is entitled to injunctive relief against KA, prohibiting KA from violating plaintiff's trade dress rights with the KA polymer lower. You would think that they would here say, you're asking for an injunction. So you think you'd spell out what you want to enjoin them from doing? Like, we want you to ban them from using this specific feature. You can't have the feel of a McDonald's. And McDonald's, if they were suing a small restaurant for violating their trade dress, they'd be saying, we want you to not have, these colors. We'd want you to not have these shapes. We want you to not have these things. That's what we want this injunction to say. Not just stop being McDonald's, please. Like, this is bad drafting in the way that says, yeah. And Mike, this just to confirm, you're at Bloke on the Range, correct?
Yep.
So, yeah, just that is the channel name. Sorry, we've got a puppy with opinions on this. He's also not a fan of this lawsuit. So yeah, Golden Arches. If you were using the Golden Arches, McDonald's would say, we specifically want an injunction that you can't use the Golden Arches at your business anymore. They wouldn't just say, stop infringing, please. So, all right. Unjust enrichment again, dilution of value. Okay. So fifth cause of action.
If you think that gets shot down at a deposition, you would be right.
Yeah,
it's proper train wreck time. It really is.
Oh,
you've got a couple of hours of your life to lose and are interested, read it.
We'll have to go through that on another one, because this will be forever if we go through all of the deposition stuff. But let's go through because there's this. We'll look at a couple of the exhibits on this, and then we'll also look at which of these claims actually keep going, because some of these claims they realize they're not going anywhere, but others they keep going, and I don't know that they've got there. I already did mention that this entire lawsuit is being funded by Reed Oppenheimer, who does not like AR-15s, wants to see them banned, and I've got a whole video on that topic. So yes, that was mentioned, but it's worth mentioning again. So when we talk about just how bad this lawsuit is, that's some important perspective of that. So I see here, Norsk Hydro used to publish vague descriptions of new inventions in an obscure Norwegian local newspaper. When some competitor tried to patent the same thing, they could prove prior publishing.
Defensive publications.
Yeah, that's classic.
Yep.
Now I'm just wondering about creating a newspaper that's got like a really, really narrow publication window, and like we distribute this to 8 different blind people in print only, just for the purpose of being a prior publication.
Technically, legally counts in the United States. Any prior publication anywhere in the world distributed to any third party. Could be to one person. It would technically count as a printed publication. Of course, you have to prove all that, but still.
So we just have one person whose job it is to receive these publications, not to read.
There was actually a case, I can't remember what the jurisdiction was, but in the middle of the night, something was published online, notarized that it had been published online, and then deleted from online. And they tried to pull that out as a publication. And I can't remember which jurisdiction it was. I think it was somewhere in Europe. And they said, look, there has to be a reasonable expectation that someone could actually access this. This is kind of in the early days when internet disclosures were a sort of new and shiny thing that people were trying to figure out the limits of. So like publishing on Dropbox with a random URL that someone could guess by sheer chance. That's not enough. That's not a publication.
You're right. You are right. I stand corrected.
But if it's and putting it up for 10 minutes at midnight with a notary notarizing the fact that it had been published at midnight, and then putting in his documentation what had been disclosed at midnight, there was no expectation that the public could have accessed that, which I think was a fair decision.
Posted this on a lamppost at a dog park for like the weekend, and then we took it down.
I think that if that was all fully certified that had happened, I think
might get there.
That would probably, I'd probably go for that.
All right, so copyright infringement. So now we need, some sort of copyright infringement here. So reincorporates everything above, and they say KA used CAD drawings, blueprints, and / or other drawings, including in the IP purchase agreement, to create the KA polymer lower. Okay, so
except they didn't.
First of all, this is not actually true. But second of all, even if it was, that doesn't necessarily get you to a copyright infringement, because copyright, it doesn't. This is something like I do leatherwork, and this is something that comes up in the leatherwork community all the time, because you'll have somebody who's like, I have a pattern for this cool product, and they say, and I have copyright over these patterns, so you can't make it, but here's the thing, this is, I didn't make this, but this is a little, it's not even leather, it's sort of fake leatherette, thing. You can, if I make a pattern for something like this, I can potentially have copyright over the specific expression of the pattern, but the pattern itself, you can't copyright, nor can you copyright the, this sort of shape, because those are functional elements. This is an interesting extension of copyright that they seem to be trying to push here. Plaintiff's drawings are protected by federal copyright law with or without registration, and KA infringed upon plaintiff's copyrights in relation to the CAB 15 and KA polymer lower. They state, so if you are, let's say I make a pattern for something and I want to protect that pattern. Like I design, Diesel Punk online has a really cool, design for like a bag. Well, you can't protect the design for the bag under copyright, but you can say, make that pattern and you could put your own logo on it, and then your logo is protected. So if somebody wants to share the pattern, they'd have to do so by creating the pattern, copying only the pattern elements. That makes it a little bit more of a pain in the... But they'd have to actually show that the copyrighted things were copied, not that somebody made a useful product out of them.
It's more than a bit brave.
It's not just brave. This is expressly contradicted by the entirety of copyright law.
Yeah.
So, yeah. And the with or without registration, somebody in the chat just made a very good point. The U.S. has some pretty interesting examples of, I think, lawsuits, and this is more, Leonard French would be good on this one. It's a lot harder to sue on a copyright when you don't have a registration of it. So
You can't.
that's a little more challenging.
Yeah, you can't sue without registration now. The U.S. Supreme Court changed that 4 or 5 years ago.
So good luck on that. All right. Misappropriation of intellectual property against K.A. Phagan and Nealon. So reincorporates all of the allegations contained in 1 to 87. I mean, some of these are just bare assertions of law with no support whatsoever. So, yeah. As set forth above, KA utilized CAD drawings, which were part of the intellectual property purchased by plaintiff from Sinistral in its development and design of the KA polymer lower. Again, that doesn't really get us to anything, because even if they did, which my understanding is they didn't, that still wouldn't get you to, because, yeah. So KA knowingly copied, replicated, received, bought, or obtained plaintiff's IP, specifically the CAD drawings upon which the CAD 15 are based, from Nealon and / or Phagan. Okay, did they? Where? How? Like, this is an assertion that they did a thing, but where did they do it? When?
And at what point did Nealon have an agreement with anyone that he wouldn't keep any in his possession and wouldn't give them to third parties? This is just like there's a whole chain of custody and a whole chain of agreements that would need to be in place to prevent him from doing that, and it doesn't exist.
This is like if I go to J.K. Rowling and I somehow convince her to sell me for some amount that I could pay all of the IP for Harry Potter and that whole series, which, it's never going to happen, but let's imagine this as our ridiculous hypothetical. The allegation here is that then it would be illegal for Kurt to sell J.K. Rowling a copy of the book, or for Kurt to sell Mike a copy of. It's like, this is not just bad. This is like fundamentally opposed to how copyright works. You can't prevent somebody from selling another copy that they already own. So,
I mean, unless you had an unusual contract where he had to destroy all previous copies, at which point that would have to be explicitly in the agreement that he does not retain any copies.
And the copyrights by Nealon, like, even if Phagan had made an agreement to destroy all CAD copies that he had,
that doesn't bind Nealon. I mean, Russ would have had to have had a contract with Nealon, forcing Nealon to destroy all, to hand over or destroy all copies and not retain any. And then Russ would have had to have had the same agreement with KEA, but then none of them did. And it would be a really unusual thing to prevent someone from retaining a copy of a CAD CAM file. I mean, you could do it. I mean, you've got freedom of contract on this kind of thing. There's nothing preventing you from having that agreement, but they don't have that kind of agreement. It's mad. It's mad. I mean, it's like they've got something with Russ, and that somehow binds Nealon because Nealon sold Russ something concerned in the past. Yeah. It's like it's like divide by zero error.
It's like if I sell Kurt all copies I have of, my Larry Niven books, this doesn't prevent me from going and buying another book that already exists. And if Kurt tried to sue me on the basis of, hey, you sold me all your books and then you bought another book, the court would have some opinions on that. I think those opinions would be best described as fuck and off. So, yeah. Okay, carrying on with what the hell. All right. They knew it was the property of plaintiff. No, it wasn't. Even by your own allegations, it wasn't. Pursuant to 18 USC, plaintiff is entitled to an injunction against KA, Phagan, and Nealon to prevent the production and/or distribution of the KA polymer lower. How on this theory? And the future use, distribution, and misappropriation of plaintiff's IP. Again, your allegations aren't that. And they're asking for exemplary damages, which is basically like bonus money. We're going to punish you extra for their willful and malicious misappropriation of plaintiff's IP, which is really just based on you guys not being good at law. I mean, if they're alleging a copy, then great. That might get them somewhere if they can show that they actually own the copyright to this, which is one of those things you might want, like a registration of copyright, or if you don't have a registration, you want a very clear chain of title on that. Like, you want a very clear chain of exchange. So, yeah.
For those just joining the stream, remember that the legal position is that literally anybody could buy a CAV 15 Mark II lower, cut it apart, make a mold, and start pounding them out for the market. There's literally no legal hindrance to doing that.
Right.
This is what's so insane about this whole thing.
But we can't call it a Mark III because that name is recognized, and everyone would have recognized it as that brand. No one else has ever called that thing a Mark III ever before.
If it was legal for me to manufacture an AR-15 here in Canada, there would be nothing stopping me from buying one of these existing Mark IIs and, making it the Runkle Mark II. I don't see how they yeah. Oh, this is frustrating. And the other thing is that the details that are known out in the public is that the KA thing was engineered not from this, but from an aluminum receiver. And they basically started from scratch and said, okay, let's start with an aluminum receiver and then go and make our own monolithic polymer lower, because you can't protect the idea of a monolithic polymer lower. It's like saying, I have the rights to the concept of a car. And you can't do that. That's not how this works. You might be able to own the rights to a specific improvement on a car that is a patentable invention, but the concept of like a vehicle is not. Yeah. So, yeah. Thank you, Ms. Pete, for the very generous super chat here. It's this is. And once again, we've got, as a result of KA's, Phagan, and Nealon's misappropriation of plaintiff's IP, including CAD drawings and derivative works, damaged in excess of $75,000, together with, we want all the monies. Breach of implied covenant of good faith and fair dealing against KA, Phagan, SST, and Brownells. So, implied covenant of good faith and fair dealing. When you make a contract, there is sort of an implied agreement that you're not screwing over the other side in various ways. But it's really hard to sue on that. If that's all you've got, you're probably losing, unless you've got some really interesting facts. And I haven't seen those interesting facts yet.
Implied is a big red flag.
Well, implied is always, but there is an implied, covenant of good faith and fair dealing. That's a thing, but you're gonna need to have something good here, and we haven't been seeing good stuff in this. I kind of feel like if they had good stuff to put in this, we'd have seen it by now. But
yeah.
All right.
I long since lost interest in this lawsuit because it was bad and it's not getting any better.
The thing is this is a bad lawsuit, and I would just be like, this is uninteresting, except that it's like, these are people who are known in the firearm community. They're sort of well-known names. They're people just trying to make a good product, and they're getting crushed, by this guy who, from his deposition, his objective seemed to be to prevent guns from being made. The whole point of these things isn't to just, the whole point of intellectual property isn't gun control. and somebody trying to use it in that fashion to pursue a political end, if that's what's going on here, is really like, what the heck? So, all right. So they say they entered into valid contracts. Okay, cool. Implied in every contract. Cool. They say that they've complied with the NDAs and the IP purchase agreement. However, they've breached their respective agreements. How? KA failed to deal with plaintiff fairly and in good faith by attempting to obtain or obtaining plaintiff's intellectual property after entering into the KA NDA. This includes, but not limited to, KA obtaining plaintiff's IP from Phagan and Nealon, despite knowing plaintiff owned the IP and that neither Phagan nor Nealon were permitted to disclose such information to KEA. Okay, how did... This is, again, sort of frustrating.
There was deposition, so it survived a motion to dismiss.
I'm not sure if did this one survive, because
you're mentioning depositions. I'm like, this survived a motion to dismiss. I mean,
well, a bunch of the claims were dismissed. We'll have to go over which ones were voluntarily killed, because a bunch of them did not survive. So, but yeah, it's... And the other thing is that we run into a problem on all of this, which is that IP stuff often survive. There may be some confusion as to like some of the background on all of this, because they might be saying, oh, well, maybe this is novel. Well, a lot of this stuff isn't novel. I understand that a big deal was made about the length of pull in this particular firearm, which predates. Yeah, they're saying it's a proprietary length of pull, except it's the same length of pull.
Except for the fact that you can literally measure it. How proprietary can it be?
And also was used before GWACS existed.
I think every length of pull that's possible has probably been done at some point. That would be like, there's some length of pull that's never been tried by someone ever. Okay, that's an interesting proposition.
So, yeah, this is sort of novel, but yeah, KA failed to deal with plaintiff fairly and in good faith by using information disclosed by plaintiff to KA under the NDA to circumvent plaintiff and enter into a production agreement for Brownells to distribute the KA polymer lowers on fully assembled rifles. Or Brownells just realized that they weren't getting their rifles and looked for another person who could make rifles. I kind of feel like Brownells is in the business of distributing firearms.
Yeah, a little bit.
Like
a little bit.
This is not like a secret in the gun community. It is not a secret that Brownells distributes guns. This is not like top secret information. Plaintiff or Phagan breached the IP agreement, NDA and NDA by gaining valuable information and insight from plaintiff under the pretense KA was working with plaintiff on the project for Brownells and in furtherance of their working relationship. Was it a pretense, or were they actually trying to get this going until your company sucked and went under? Like, those are different things. And did they use any of this information and insight in any fashion? Because gaining valuable information and insight is one thing, but did they use any of that information? They haven't disclosed how that happened. So again, failed to do so, or to deal in fairly and in good faith by using information under the Brownells NDA to circumvent plaintiff and enter into a production agreement to distribute the polymer. An NDA isn't a non-compete, and they're trying to use the NDA as a non-compete here. Like, you can't do business with Brownells because we were doing business with Brownells. That's not how that works.
No.
So, so again, they want all the money. 8th cause of action, breach of contract. They just keep going on cause of action here. Hopefully we're getting close to the end. So SST represented it had sole exclusive good and merchantable title to the IP, free and clear of all pledges, claims, liens, restrictions, etc. We'll see exactly what they represented. as we look on here. If it didn't own the intellectual property, then it breached the IP purchase agreement. Or they just say, hey, we're giving you all of the IP we have. Like, that's a different thing. Because if I say I'm giving you all of the IP I have with respect to my Harry Potter fan fiction, well, then you can gain the IP for the novel elements I wrote, but that doesn't give you the underlying IP to the Harry Potter universe. So, and I see, are they throwing everything out there just hoping something sticks? Certainly seems like it. So, yeah. I have distributors, manufacturers undercut me, but I don't have everything riding on a garbage volume product. Yeah, it's, yeah. And I'm pretty sure if a CAB 15 and KP 15 existed at the same time, Brownells would probably stock both receivers. Absolutely, they would.
Yeah.
Brownells stocks all sorts of things, right? They're a huge player, and you bet that they want to, stock various options there. And yeah, KE Arms didn't use the GWACS molds. Of course, they didn't. GWACS stopped making rifles because they had worn out the CAB 15 molds they purchased, and they couldn't figure out how to make new molds. That's where they ended up there. So, all right, carrying on here. Further, pursuant to the IP purchase agreement, SST is required to indemnify plaintiff in the event claims are brought against plaintiff relating to the assets sold thereby, which include the IP. So let's hope you've got specific details of what the IP is, because if it's just all IP that you got, then that indemnification isn't going to be super useful, where the claim is that something, that you didn't get something because they didn't have it. All right. And so they want all the monies. Another breach of contract against Brownells. So again, they're talking about the know-how, trade secrets, etc., and shall use the proprietary information only for the purpose set forth in paragraph 1 hereof. And they're saying that it was disclosed in various ways, but they don't specify. They want an injunction. Sorry, I'm going a little faster here, but this is getting a little repetitive. And they want all the monies. So now here's the prayer for relief, which basically means
I have my own prayer for relief.
Is the prayer for relief.
Sit down and shut up.
Oh, so they want, so this is basically all they want. They're saying judgment in the excess of $75,000 and other relief that this court deems just and equitable. Other relief is basically just give us anything you think we can get. So they're asking for more than $75,000. I understand they're asking for amounts in the, possibly in the millions at the end of all of this. And yeah. All right. So all of which is respectfully submitted by Jones, Gotcher, Bogan Professional Corporation. All right. So that was...
It's over. Yay. That's
well, sort of.
Oh, no. There's more. Damn it.
More.
I was excited.
Because we've got to look at the asset purchase and sales agreement, which is Exhibit 1. Because this is what they're saying they got. So, agreement made between Sinistral Shooting Technologies and GWACS. So, seller owns business assets located in Gilbert, Arizona. I don't care that much. They desire to purchase or to sell, and the purchaser desires to purchase. Why is this clause even in here? This is the sort of clause that if you were doing contract drafting, you should probably not include, because no kidding that they desire to engage in business. Like, nobody wants to sell anything, but we're doing this contract because, for giggles. I don't know. All right. Purchase of assets. Free and clear of all liens as to the assets and so forth. So this is what they're relying very heavily on in terms of the sole, exclusive, and good and merchantable title to the assets. So let's see what assets they describe here. All right. So there's details about how it's getting paid and purchase price and closing date. Expenses, disclaimer of warranty. None of this is super important. Let's get the assets. So seller has good title to the assets of record and beneficially, free and clear of all liens, titles, claims, encumbrances, and restrictions of every kind. Great. They're looking for that. Where are they actually going to detail our assets? Because a lot of this is just, oh, and here's the indemnification aspect, which again, they're going to say is super important. But assets are normally something you'd want to list fairly clearly here, but oh, this is not listing counsel. Where do we have the assets? Assets, here we go. Because this is important. This is what they're actually buying. One, Van Don 300 press, HT series model, etc., with a particular controller. Cool. A plastic dryer with hopper with a particular serial number. Cool. Vibration welder model. Cool. That's a physical object. Takedown pin sets, another physical object. Serial number tags, another physical object. CAD drawings, design prints to the molds, including any and all intellectual property IP related thereto. That's real unspecific.
That is so unspecific. Who wrote this?
The same law firm that is running the lawsuit.
CAD drawings, design prints to the molds. First of all, is that two things? Is that one thing? Are those things related? Are they okay? Including any all intellectual property related to what? The molds, the design prints to the molds, the CAD drawings. What? Okay.
The way I'm reading that is that it's a catch-all that is saying that I'm selling you all this stuff, but I'm not going to. But I can't sue you later for infringement of any IP on it. I think it's intended to be a guarantee to the purchaser that they're not going to do some absolute dick move like sell this and say, haha, well, we've actually got a patent we didn't tell you about, and I've seen that you've been using the equipment I've sold you, and now I'm going to sue you for patent infringement. Although there isn't a patent in this case. That's about the only way, to me, that clause makes sense. It's just a catch-all that there's not some dick move trolling, some form of dick move trolling going on, basically.
What CAD drawings? Which ones?
Yeah.
All CAD drawings? Some CAD drawings relating to what? Just CAD drawings. So, I mean, technically under the terms of this contract, I could just generate two completely new CAD drawings and be like, well, here's the CAD drawings. These are CAD drawings. This must be what you wanted, right? Design prints the molds. Which ones? Oh, I just made some new molds just now. Here they are.
Yeah, you want to be specific about these things when you have a contract. Like, if I'm selling Kurt a house, Kurt's going to want a contract that indicates precisely which house he's getting.
The address would be nice.
You know, an address, land description, title, like not just I have sold Kurt the house, because at that point, I could go and find like a condemned house and be like, here you go, Kurt. And he's going to go, this is not the house. And now we're stuck in litigation that you want to avoid. One of the fundamental purposes of contract drafting is to prevent litigation. A good contract lawyer charges you, $5,000 to do a contract to save you $50,000 in lawsuits down the road. This is not good contract drafting. This is not, yeah. And so bill of sale, again, just talks about CAD drawings, including all intellectual property. So it's going to be really hard to say that you have specific, that you've got some right to a specific copyright when it's not clearly spelled out like this. But
intellectual property rights that exist as of what time?
Yeah.
What if new intellectual property rights get developed as a result of whatever? Derivatives of those things.
Well, and there's, if they're going to be trying to represent that they were told that they would own the copyright to this, like this doesn't say you have the copyright to this specific CAD drawing. It's just all intellectual property. Like I'd read this as all intellectual property that they actually hold.
No, this is like a residual clause. This is like your last clause. What you really want is the list of specific things, and then you have some version of this is like, and by the way, all the other stuff that we failed to mention specifically. But you want to mention all the specific things first. Like if you know there's specific CAD drawings, if you know there's specific related to specific products, why just mention all the specific things, come up with every specific thing you can think of, and then you have a residual clause, like all other CAD drawings, blah blah blah, whatever, so that but you don't, if you know specific ones, you don't want them just to be part of a catch-all,
like say, I don't know, the CAV 15, the CAV.
That'd be great. That'd
CAV
be good.
15 Mark 1, CAV 15
there you go.
Mark.
There you go. That's exactly what we're talking about, right? That'd be great.
Because like if you go to, lots of people, if you're thinking, here's a fun example. Like if we look at GWACS has, people know like, the various, the Glock 19. So you know what the Glock 1 is?
Well, I know the first 16 things were not firearms. Wasn't it a shovel or something?
I think 1 and 2 are like a hinge and a doorknob.
Yeah.
I can't remember exactly, but basically he got machines and started making stuff, like various random things. And it wasn't until he got way down the line that somebody said, hey, let's, why don't you try making a gun? Or he said, I think I'll try making a gun. And everyone thought he was crazy. And then he actually made a really good one. So
Glock 17 knocked it right out of the park.
Yeah. Like just this random guy out of nowhere with no firearm design experience. Just like, hey, I've just decided to make a gun that is better in many ways than the existing firearms out there. So yeah. All right. So we also have the non-disclosure agreements, because those are kind of important here, because you would think that they'd want to detail some things in this, and proprietary information. I guess spoiler alert on all of this, like they really don't. So competition. Each party acknowledges that the other party or its affiliates may be in the process of offering or developing products or similar or services that are competitive with and potentially similar to the products and services which it offers or intends to offer, and agree that this agreement shall not preclude such offerings or development, irrespective of any competition with or similarity to its products or services, so long as the other party's actions are in compliance with the obligations under this agreement with respect to the proprietary information. It's explicitly and specifically not a non-compete.
Yeah, and the exclusions are the best bit.
So yeah, I'm trying to remember where they put there. So limitation on obligations. This is an exclusion clause. This is stuff that is not like specifically intended not to be covered here. So one, or A, at the time of the disclosure was already in the possession of the receiving party. Now, at the time of this agreement, which we have as executed the day and year first set forth about, why do they draft this in such a jerk fashion? Okay, 2015.
Because it's a boilerplate.
Yes,
it's a boilerplate agreement that they haven't adapted to the specific situations. They just get everyone to sign the same NDA, and that's it. And they really haven't thought about it, which is why this is how it goes. But the thing to remember here is that the receiving party is Phagan or KEA or Brownells here. So this is like opposite to the chain of custody of the molds and the information.
I'm just going to go out on a limb and say that Phagan knew a ton about, monolithic polymer lowers before this lawsuit ever started. Yeah. And when you talk about Carl of In Range TV, what did he know about firearms before any of this?
All the things.
More than I can contemplate. So when you're talking about the limitations, exclusion clause A here is so huge. Like, this is basically like excluding North America. It's like, this is huge. B is independently made available to the receiving party by a third party not bound directly or indirectly by a non-disclosure obligation to the disclosing party. Was Nealon a party to this? Whoops. This is a problem. Also, was the entirety of the world, because, once you disclose what your product looks like to the world, then you've got a really big issue on, non or third parties. C is in the public domain. Lots of stuff about AR-15s is in the public domain, which is why there's so many available.
Yeah. And as we said before, the first time that Cavalry sold a Cav2 receiver to the public, which was like back in 2000 and God knows what, that put all its analyzable secrets in the public domain. It was disclosed to the public on that day of that first sale.
Oh, it's going to get even better than that, though. It's going to get so much better than that. And I'll bring that up in just a second, because, oh man, I don't know what
something you didn't share with me earlier.
Just another thing here, but this is some clown shoes moments. GWACS, but is independently developed by the receiving party without reference to proprietary information received from the disclosing party. This is exactly what happened. Like, there's a chain of design from aluminum receiver to new monolithic polymer lower. So prove that you can do any of this. Like, how you prove that this NDA was violated, I just have no idea. The problem is this is normally a lawsuit you'd want to take to somebody who didn't draft these agreements, because you may actually have an argument that the people at fault is the drafter of the original agreements for screwing it up. Like, that is something you'd want to contemplate. And there's a conflict inherent to this file that I see, which is that the people like this, because it's the same law firm, they have a very strong incentive personally to see that these original contracts hold up, because that protects them. Whereas an independent, a new lawyer would say, listen, we may have two separate angles we have to take. One of them, we've got this weak sauce lawsuit against, KEA and so, but they might also want to pursue a claim against the original counsel for, you screwed up and now we're on the hook. That additional cause of action creates a big conflict. And I would not personally run this file. If I was the drafter of the contract, I would be saying, like, listen, I need to contact my insurance provider and let them know that I'm potentially about to eat a lawsuit, and I'm available to be deposed about, my decisions on this and how it came about, because that's just ethics, right? Sometimes ethics for your client includes answering questions about why you did a thing and whether or not it's maybe your fault. Because yeah. But let's talk about how well GWACS protected their IP, because we've got a really interesting thing here from 2018. And so this is, it's in reverse order. So their response was, does this help? But the question was, greetings. I recently bought one of your lower receivers, and so far I'm liking it, but I need to modify it for some sling points. Is there any way I could be sent a picture of one of the receiver's halves insides before they're welded together? I understand any modification like this wouldn't be covered under your warranty, but I'm not planning on doing anything crazy, and this is for personal use only. I tried finding pictures online of a receiver that's split or something, but lo and behold, there doesn't seem to be any pictures everywhere of your receivers failing, regardless of what the rumor mill says about polymer. Thanks, and I've redacted names and details and so forth. So this is somebody saying, listen, I want to start drilling some holes in this. And can you send me some pictures so that I know where I can't drill holes, like where I'm going to hit structural elements and I'm going to wreck my rifle. Now, properly, if you're saying that the inside of your rifle is secret, the response to this would be something like,
No.
go to. But instead,
sure,
the response,
let me send you copies of it.
Yeah, the response is, does this help? And look at the pictures they sent with a helpful ruler. Now,
That is helpful.
A moderately competent engineering student, no, not engineering student, could throw up a CAD drawing of this, now in an afternoon, based on these pictures. Mm-hmm. So saying, hey, this is our trade secret, but we send it out in email to any rando who asks. I feel like these are not...
that's what we call not a trade secret anymore. Because you did the one thing that you need to do with trade secret, which is maintain the secrecy, which was already pretty hard because anyone could have split it in half themselves and just looked. But, assuming that was not an option, that really goes a long way to, yep, you're dead. You're dead in the water.
Yeah. And I mean, normally you would say something, maybe they could say, hey, listen, nobody could possibly have split this open. I don't even know how you'd actually get there because water cutters exist, but like,
but it's such a basic
it's made of unobtainium, so it can't be split in half.
Yeah, I mean, it's such a basic principle. It was one of the European qualifying exam law questions back about 15 years ago regarding novelty in patents, and which is the same standard applied to trade secrets. I mean, it is literally a schoolboy question about whether the inside of an object remains a secret once an object's been sold. It's so basic.
Yeah, and the answer to that is no.
Not really, no.
Like the question thing he's referring to is basically, if you show the assembled receiver at a trade show, then you can still say that the insides of it are a secret because nobody's actually been able to take it home. But once you give one to somebody or sell one to somebody, now the public, that one person of the public, has the right to chop it up and, distribute it and so forth. So
whether they did or not, and whether they had any reason to or not, it's an absolute. It's an absolute standard. It's really very tough.
Yeah, they could have, and therefore,
it was sufficiently exposed to the public. That was going to what he was talking about earlier with the publication thing. Like as long as there's a fair opportunity for the public to be able to get access to it, you don't have to prove anyone did. And this also is used in publications. The classic sort of example of this is someone's thesis, which might be printed and put on a library shelf. You don't have to prove that anyone ever checked it out. You just have to prove that someone could have. It was available. It was in the card catalog system for someone to look up. Someone could have looked it up. And as long as it's reasonably available to the public, as he was alluding to earlier, you're there. And so it's like, well, you sold the thing. Someone could have cut it up. It's exposed enough. So eat it.
Now, some of these claims go away. We've got a stipulated partial dismissal without prejudice. So some of these claims have been sort of knocked out. All right. So in KA's counter complaint, they brought 3 causes of action against defense. So these are dismissed without prejudice, but they reserve the right to pursue its cause of action against Armory in the event that a judgment is obtained against Armory and execution returned unsatisfied. They reserve the right to pursue theories of vicarious liability and alter ego theories against defense in accordance with this. Now,
is one of the alter egos someone who's competent?
Well, this is an interesting element. So, to explain what's happening here, there's 2 companies. There's GWACS Armory, which is the gun company, and there's GWACS Defense, whose main product is an acoustic gunshot detection system. As far as I can tell. GWACS Defense versus GWACS Armory.
Okay, fine.
So the only business that GWACS Armory seems to still be involved in is holding on to guns, because occasionally GWACS Defense needs guns in order to test their systems, and so nominally GWACS Armory are the people who show up with the guns. The problem is they're the same people, and they apparently send emails interchangeably from one to the other. Like if you have GWACS Defense business and you send it to GWACS Armory, you're gonna get, like, they will respond. So they've got a real problem of like distinguishing things, which is a super big problem when you're actually talking about licensed firearms businesses, because this is how you can accidentally felony. And I'm not saying they did or didn't, but this is the kind of stupid game that you should not be playing. This is like, I bought a bunch of unknown guns from some guy in the woods, and I don't know anything about them. And maybe some of them are legal and maybe some of them aren't, but I'm not going to look in the box. Kind of stupid games. Because if you get this, like when you're playing around with firearm licensing stuff, if you get it wrong, there's like this little tiny cliff from I am perfectly legal to I am in worlds of shit. And I can't say whether they've stepped off this or not, but this is the kind of behavior that is dancing on that edge. And so this is the kind of thing you would normally tell people not to do.
Your little bat alert legal signal is up, right? It's like danger, Robinson, danger. This is the kind of thing that if this is the kind of thing that's if your client, you're like, we need to have a chat.
When you're starting to say like the legality of this depends on this very subtle distinction, you want to make that subtle distinction not so subtle, or you want to make it go away. And so like, I'm not alleging any sort of crime has been committed, but this is dangerous behavior. And I think that's a fair statement here. But that's why they're talking about defense versus armory. And so what they're saying here is basically, if we get money from armory, we may turn around and also want money from defense. And there's some good reason for that, which is that they might functionally be basically the same thing. So, they're not giving up as against armory is sort of the critical thing there. And similarly, we see some things with respect to Mr. Gudgel specifically. Judd Gudgel, again, is the president, I think, of GWACS.
Which one?
Yeah, I think both, actually, but I'm not certain on that. And although when I say president, I think Oppenheimer owns like 40% or something like that. I think Gudgel has like a much smaller slice at this point. So, yeah. Yeah, I see somebody saying legal to federal prison in 5 minutes. Yeah, it's like the same thing in Canada. If you have a firearms business license that allows you to own prohibited firearms, for the purposes of making a movie, you don't leave it to the last second to renew that license, because the second that license expires, you are in a universe of shit. So, like, waiting till the last second is that sort of flirting with disaster. That having two companies for that is also the same thing of flirting with disaster. So this is not great. All right. Kay versus Mr. Anderson, same thing on all of that. And I think I'm looking at the wrong partial dismissal, because let me just find the right one, because there's a bunch of them here that go away for the other way. So I see, all the claims against Gudgel and Anderson go away in that one, because it's the companies they're really after. So, what is that? Plaintiff dismisses its third cause of action for trademark infringement. which, what did we think of that trademark infringement claim?
Pretty bad.
Yeah, real bad. They also dismiss their fourth cause of action for trade dress infringement. That one is somehow worse than the trademark infringement action. And it's
what
fifth cause
trade
of action.
dress? It's like, what trade dress? How is it styled in some way that represents a unique brand identifier?
They're not even able to articulate that in their complaint.
Yeah.
And
at least they said Mark III as a trademark. At least they had a claim to something. They said they had.
Yeah.
Like, what is even their theoretical trade dress?
Yeah, I don't know. I don't normally do like IP stuff. I took some IP classes. I've got some vague interest in IP because I think it's a fascinating area of law. But I actually looked up some lawsuits about, these kinds of issues like trade dress infringement. Every other lawsuit I looked up, when they were alleging trade dress infringement, they get real specific in the pleadings. Like, not just you used red and yellow and, these shapes, but you used all of those things together. And, here is pictures of our restaurant and here's pictures of their restaurant. And you can see how there's going to be confusion. We have, an affidavit from somebody who points, an expert in confusion who's going to talk about this. We have like all of this stuff. But at the very least, the absolute minimum standard is basically to identify the specific elements of trade dress. And they can't even get there. They just say there is trade dress.
Yeah.
And yeah, it's bizarre there. So we've got awesome story. Purchase some KE Arms stuff to support. Excellent. Any insight on a Webley Mark 6 P&H 22 long rifle conversion? Thinking of purchasing one.
Actually, I'm unaware that Parker Hale did any Mark 6. Was it conversion or built like that? But usual things to check over with a Webley are the timing, as with all revolvers. But a lot of these, if they were trainers or people's personal target pistols, oftentimes the timing is shot. So check that out.
And that can be expensive to get fixed because not all gunsmiths are good at timing.
Oh, and how many gunsmiths know intimately how to work on Webleys these days?
You're probably looking for like one specific specialist who can, and if there's one specific specialist in any particular area, you better believe they have a lineup, and getting to the front of that lineup or even into that lineup costs you a whole lot of cash. So yeah.
But if it's in spangly order and the timing's all good, go for it. It's the sort of thing I would quickly go out and get myself a permit and buy if I came across one. Yeah,
that shiny stuff there. And its fifth cause of action for copyright infringement. Well, again, they haven't been able to show that any copyright was infringed at all. So yes, but they are keeping their breach of contract, misappropriation of trade secrets, and misappropriation of intellectual property, and their breach of implied covenant of good faith, and breach of contracts and breach of contracts. So really what they're trying to proceed now on is a contracts aspect, but it's kind of interesting that, the aspect of the contract that they're saying is breached is misuse of the IP, that they are now dropping all of the IP claims. We acknowledge we don't have any IP, but they misused our IP anyway.
Neat trick.
Yeah.
I missed that one in school. I have to be honest. I missed that we don't have IP, but they infringed our IP. I missed that lesson.
And here's the law firm: Jones, Gotcher, and Bogan Professional Corporation. The same people who drafted the contract. It's law students out there. If you potentially, and I mean if there's a whisper of a chance that you screwed up the original issue, you should not be handling the litigation about that issue going forward.
Yeah, creates problems.
I mean, the other thing is like, you protect, like, if you hand this off to another lawyer and that other lawyer decides that they don't want to sue you over that, that's pretty good, pretty good buffering against you getting sued for it in future, because they would have at the time. But if you did it, you may actually have renewed the issue by not pursuing it. You can actually extend your limitations on all of this by this kind of stuff. I'm not going to go into a full ethics thing, but like when I run a trial, if I think that there is a possible allegation, possible whisper, like if I made a decision not to call a witness and I made that decision for tactical reasons, I stand by that decision, but I know another lawyer might disagree, I don't run that appeal, because I want somebody else to be able to say, you know what, Runkle screwed up by not calling that witness. That is in keeping with my duty to my client, because that persists, right? And maybe I did screw up, right? You don't want to be the person trying to make that call. So, yeah, I got some criticisms here. A lot of those claims should never have been filed, like the trade dress and so forth. Like, that should never have made it onto paper. I don't think that the ones that are still here should have made it onto paper, but the problem that you run into is juries. What do we all know about juries?
Yeah, it can be a bit difficult, unpredictable sometimes.
Yep, sometimes juries suck. Especially when we're asking juries to do things like address complicated technical points.
It amazes me that the US has juries in complicated technical cases like this, and complicated civil cases.
Yeah. I would have thought that this should be run in front of a justice, but the other problem that you run into is
the judges aren't much better. Yeah.
The other problem you run into is just that firearms are politically contentious, and judges and juries are not immune to these kinds of things. And they could end up with a jury pool that says, you know what, we're actually 100% behind Mr. Oppenheimer's quest to rid the streets of AR-15s, because that's what we think too. And so they might rule just basically on the basis of, like, screw these guys and they like guns. So that's another possibility that we could see here. And right now, GWACS are the people with deep pockets, because they're being funded by this massively wealthy venture capitalist sort of, and they can grind them down. KE Arms is having to do fundraising to try to stay afloat for all of this. And one of the sad things is that you can lose litigation by running out of money. And I think that might be something that they're looking for here too, is if you guys just run out of money, then we win. And so this is really unfortunate. Like, as I mentioned, I don't have any, I think the financial ties I have is I'm a Patreon supporter of InRange, because that lets me on their, Discord and lets me, chat with people. I think that's to the tune of, I pay them. I forget if it's like $5 a month. InRange TV pays me nothing. I get no financial benefit from them. I've sent them money to go on brutality events and so forth, but so conflict of interest. I don't see. I'm. Yeah.
It's a weak lawsuit as written. It's too conclusory. It doesn't give you
Yeah.
enough information about what specifics are going on. There does seem to be some problems in the underlying contracts because they're not specific enough in the first place, and include an exemption clause that basically eats its own tail. There's problems in every aspect of this lawsuit. And like on a fundamental level, I don't even understand on some level what they think happened, because it's just all conclusory. Well, they violate RP, they violate our non-disclosure. It's like I don't even quite. Their storytelling in their complaint is horrible.
Their contention seems to be that no one else could have decided to make a monolithic polymer lower without their secrets.
I'm going to go on a limb and say that people have been making monolithic polymer lowers basically constantly for like the last 30 years.
Since before I was born.
Yeah.
Like,
so, yeah.
Steyr were doing it in the 70s.
Yeah.
Yeah.
So I don't think the monolithic polymer lower is what gets you past the point of novelty.
Yeah, it's bizarre. They just...
Plus, even if there was a point of novelty, at one point, it doesn't matter anyway, because they never filed a patent. So I don't care in any event.
Yeah, this is...
It was the
problem.
Oops, sorry.
That contract feels like, you know, I don't want to say something they downloaded off the internet, because I don't think that's what happened. I think that this is a precedent that they just use internally as a contract, but it needed some more adaptation, right? This needed to get real specific for when you're dealing with this kind of transaction.
Yeah.
And it didn't. So, yeah, how do you sue on a contract that vague?
No, I think you got some real problems. You got some real issues.
Like, hey, you can't do anything with this IP except everything. I mean, especially when you're dealing with, when you're dealing with a technology that has been out since the 60s, as we see in the chat here, you really want to be very particular as to like what innovations you're trying to protect.
Yeah.
What IP you're trying to protect.
And for those that don't know, KE own one of the two Colt polymer lower M16s known to be in existence. It's the one in Ian's Forgotten Weapons video, is the one owned by KE. So it's like they went out and bought one of them as part of their design process.
I wonder, is that technology that was independently obtained by a third party, or that somehow pre-existed the agreement?
It's as if they expected Russell to wipe his memory.
Yeah. And Russell is like, he is the expert on this at this point. He is like, if you were wanting to start a company making monolithic polymer lowers, you would want to call him and be like, hey, can we hire you as a consultant? Because he's the guy. And you know how much he's the guy? I just want to show this because
this is
the funniest thing. This is the funniest thing that you will ever see. Let me just find the right video here. What's this titled? I'm just having trouble getting it to find the right thing. All right, I might have to do this another way here. Share. Why is this not coming up?
I feel your
Sorry,
pain. The other night I was having such internet problems, like Google Home wasn't cooperating, man. I was getting so angry, like, because my browser wasn't working, and I was just like on stream. I'm like, I feel your pain.
Oh, it always sucks when you're trying to do something live and you're trying to bring something up, and it's like, nope, I am not going to cooperate because nuts to you.
And I never even figured out what the problem was. It just started working again the next day for no particular reason, which is even more fun.
All right. I might have to do this sort of a... let's just see here if I can get this to work right. Oh, great. Now screen sharing's not working at all.
Mm-hmm. That's good news.
Let me see. I might have to reload.
You're handling it better than I did, because the other day I wanted to like break my desk. It was making me so irritated.
Give me a second. I may have to reload this screen here. So, there we go. I've got it fixed. All right, Here we go. Are you guys able to see this? Is this big enough for people to read?
I do see it.
So this is
that's small though.
GWACS Armory, their webpage. I don't know if. Let me see if I can make it bigger here.
There we go. That's a little better. Thanks.
Again, GWACS, you guys should really just keep your brand and then go into business making products for like CD.
I think you should hire some people on Fiverr to help you with a logo or something. Because
yeah, this looks like logos I rejected for my business. So, but they've got a page on history of the Cab 15. And it says, here's an interesting article. So they're recognizing the expertise of a particular individual on the internet. And the URL is http://sinistralrifleman.com. Pro tip for people involved in litigation. Maybe you don't want to talk up the expertise in the particular area of your opposition. So people saying that they can't read it, hopefully this is big enough to read it now. That's the URL, sinistralrifleman.com. Thing he wrote in 2013 about the history of the Cab 15. Yeah. We acknowledge the expertise of the other side in terms of knowing this. And when his history, I'm not going to go through his history in terms, because it's a really long post on all of that. But like when his history sort of says, hey, I was able to do a lot of this development independently and so forth. His history is absolutely destructive to their claims. So when they're going to get up and say, well, no, we disagree with his take on things. It's like, do you though? Do you really? Because you're actually citing it as authoritative. See here, he literally wrote the book on it. Yes.
Okay.
Like,
I need to sign off for now, but I just want to say thank you for the invite.
Thank you for joining us. Really great to have you here. It's, this one just makes me rage.
Yeah, I understand. All right, I'll talk to you guys again soon.
Talk to you later. Cheers.
Cheers.
So, yeah, this is, I see people saying cool website from 1998. I mean, their webpage is old because in part they haven't actually been in business for a period. They announced publicly that they were out of business. And, from a tactical perspective, if you're looking at going into a monolithic polymer receiver thing, ideally you want to be the only people in that business. So why might somebody go into that business? Because if you hear that somebody, a potential competitor has announced publicly that they are no longer in the business and that they are getting out of it, that's not proprietary information via the NDA or anything like that. That's just they made a public statement that they're going out of business. And so now might be a good time to develop your own from original materials thing. So, like looking at, we can't go through all of the documents here because there's thousands of pages. Like, pulling all this off Pacer. I can tell you guys, it costs like lots of money, hundreds of dollars to pull all this off Pacer, because Pacer's not cheap. I don't know why the US bills so heavily for all of this stuff, but like hundreds of dollars to get all this information. But it's worth it. But it's so much info. There's so much stuff out there, and a lot of it is super boring, but we're not going to be able to go through everything. But I do want to keep on this. I want to go through and look at some of these other documents as we go, because there's some real BS happening in this, and it upsets me. Like, this one actually makes me angry, because I hate seeing people sued over such weak ass BS, and especially where there's this hint that this is not for legitimate purposes, that there's some other reason for the lawsuit. Lawsuits should only be used properly for when you've suffered a harm, right? Like, I was run over. I have suffered an injury. I lost work. My leg doesn't work the same as it used to. I can't do the things I used to do. You know, I would like to be compensated for that injury. But you shouldn't be using it for, like, I hate this guy, so I'm going to sue him. Or I want this business to go to business, so I'm going to sue them because I just don't think that they, you know, if you sue the local bar, not because they're harming you, but just because you are fundamentally opposed to drinking, that's some BS. And yeah, I've got some concern on all of that. So, and frankly, I think it's kind of telling when they're like, we want to stop them from saying this stuff. It's like, well, is it lies? No, that's in your deposition. So, yeah.
And on the substantive side, okay, I'm a hard IP guy, and when I first discussed this with Russ, the first question was, so they got a patent then? No.
Yeah.
They got an industrial design? No. So what's the basis? And he explained it, and we weren't on video, but my jaw was just dropping like that. And some of the things in the depositions, it's just absolutely jaw-dropping how incredibly vaporware this whole thing is.
Yeah, I mean, I have a channel, Runkle of the Bailey, which is what you're watching right now. I have a trademark application in, because if I want to stop somebody else from making a Runkle of the Bailey anything, the way to do that is with a trademark, right? It's not by, hey, I've just got this channel. Hey, I've got this channel is fantastic, but it's not enough, right? It's not what I want to, to use to protect myself. It's just, you want to actually do better than that. It's bizarre. And yeah, let me just see if I can go a little bit. This might end up going a little bit Inception here, but I'm just browsing on the InRange sort of web, or sorry, not the InRange, the GWACS webpage here. I'm just going to see if I can pull this up. So, GWACS Armory. We're thankful for InRange TV's What Would Stoner Do project, expanding the interest in the GWACS Cab 15 product. With this interest, we have virtually sold out of our Cab 15 product line. This year, the Cab 15 Mark II turns 15 years old, and unfortunately, during our last production run, our injection mold reached its end of life. So, yeah. And they also, we've incorporated some features recommended by Russell Phagan, aka Sinistral Rifleman, who's been involved in the Cab 15 since 2001. So, do you think that some of those might have been developed before he had any connection to any of this? Like,
it's mad. I mean, yeah. and claiming that the fact the mold was worn out was like tip top super secret squirrel information when they put it on their own website. It's just like, sorry, I'm going to be vulgar. This is real pissing down your neck and telling you it's raining at the time.
Yeah, and
however many $100 or $1,000 an hour.
And they're going to take this in front of a jury. They're going to try to bullshit the jury, and they're going to try to do it basically at Russ and, KE Arms and everybody's expense, hoping to run them out of money and hoping to shut this down. It's and a lot of I don't know. I think I wouldn't want to sign my name to a complaint where there's so many details that are contradicted by stuff that's publicly available. There's a point where you tell your client, hey, we need to have a real talk about what you've been telling me versus what's on the internet. And I always have this talk with clients, hey, let's sit down and I need to know your Twitter feed. I need to know your Facebook page. I need to know all of this stuff, because if you're going to say something like, hey, I never, punched that guy at the bar, but your Twitter page says I totally smoked that guy in the face because he, I need to know that detail, because otherwise you're going to have a bad day in court. So, yeah. This is so frustrating. I see somebody just got here. Wow, Runkle plus the bloke just arrived. This is fantastic.
Too kind.
Oh, absolutely. This is actually one of the really cool things about having ventured into doing YouTube stuff, is that there's all sorts of people making great content, and you get to sort of interact with your heroes in weird ways. It's so. Yeah, I'm super thrilled to be, talking about this. And why didn't they just make a new mold? Because they're bad at business and they failed. And it cost money, and they couldn't get that money together, notwithstanding the fact that In-Range TV had created all this demand. And In-Range TV was basically, from what I understand, they were basically begging them, when are you making the next model? And they're like, too bad, going out of business. It's well, somebody's got to do it. So why didn't they just make the new mold? Because they suck. They just, and yeah, that's why they didn't make the new mold. That's sorry, I missed how this survived dismissal, because it's complicated.
And the fact that there's no there makes it even more complicated, because it's not obvious to people who are not IP specialists why there is no there. Basically, it's like wrestling with jelly. There's no meat to get your teeth into when you're up against an completely unfounded claim where it's just based on you're arguing against steam. Basically, it's horrible.
In law, there's this really weird thing where there's a certain level of bullshit that makes you nervous. Because if somebody's bringing a claim and I'm like, okay, there's, some real merit to what they're arguing here, but you know what? At the end of the day, I think that, I think my position is the stronger position. Then I'm in a position where I understand the claim and I feel confident that I can attack it. But if somebody comes at me with something and it's just like noodle soup, and I just don't know what the heck they're doing, I get worried, because there's two possibilities. Possibility one is the other side is crazy. And this happens, right? You end up with lawyers who just want to argue a point that is just zany. But before you decide it's zany, you have to have really done your homework, because possibility number two is that you are about to get clowned because you don't know this argument that's about to hit you. And so you have to actually look into whether or not you have to do a lot of digging. So when you get a ridiculous argument, something that is just stupid, it makes lawyers and judges nervous. They're going to be less likely to just dismiss it on the basis of, well, I don't want the appellate court to understand this issue that I missed and then, laugh at me. So, yeah, and I see somebody noting, you have to remember GWACS didn't make the mold they were using. Yeah, they didn't have the expertise in mold making. Who did have that expertise? Oh, right, other people. So, yeah. So, I think that's part of how it survives dismissal, is that this thing looks so weird that it makes everybody involved nervous. I will admit, I spent a whole lot of time. Like when I said, like, hey, here's this complaint, I was like, I need to talk to some experts because this looks dumb to me. And yeah. So yeah, and I believe that when GWACS was looking for money for a new mold, that's when the anti-gun angel investor bought in with the goal of driving the polymer receiver out of the marketplace. I mean, yeah. It's and he's basically said he won't fund another mold being made. He has no interest in that. That's in his deposition. He could, but he won't. Like GWACS could be knocking out Cav 3s or Cav 15 Mark 3s.
And they could be one-to-one copies of the KE Arms ones. They could reverse engineer KE's product if they wanted to. There's literally nothing stopping them because there is no IP on, no actual IP on it.
Yeah. It's bizarre. So, like, just compete in the marketplace, but that's not what they want to do. They don't want to compete. They just want to push a product out of the market. And yeah. Can legal costs be awarded if justice gets served? I believe there are counterclaims going on. So it may end up that GWACS ends up owing KE and Sinistral a bunch of stuff. Now, this is going to be interesting because I don't think that they've got a lot of like cash on hand for GWACS Armory. What I understand from their depositions is that their assets are basically a bunch of leftover crap. And a lot of it is what they were calling blems. So like blemished or otherwise imperfect product that they were using for like warranty repair and so forth. This is not what you call a giant payday if you get a big judgment against them. So a big aspect on that might be if they get, if they can make the hop from GWACS Armory to GWACS Defense. GWACS Defense actually has a product that's out there that, gunshot detection system. I don't know what KE Arms would want with that. But I mean, I do know some some landowners who might have a use for that. There's people out where I am who own hunting land and get real upset when somebody else is poaching on their hunting land. So maybe something for like an alert system that they can use to call Fish and Wildlife to say, hey, like somebody's poaching on my land, please go bust them. But I kind of feel like at the end of the day, they're, they're sitting there having some difficulties there. So, yeah, it's a headache. I don't understand what's going on here. Oh. And somebody sent me a, let me just pull up here. So, Throwback Thursday, Russell at the MGM Ironman 3-gun match 2002 with a Cav 15 Mark 1 Generation 3 receiver. Are they going to claim trademark on Generation 3? This one has been shortened to A1 length versus the original 14.5 length of pull of the Mark 1. The popularity of the shortening mod resulted in the Cav 15 Mark II current production being made A1 length. 13. Oh, A1 length. Does that suggest pre-existing?
Yeah, it's insane. It's insane.
Yeah, this is so frustrating in terms of what we see here. And like, oh, look, when we're talking about, who's our expert? Russell. Do you know which Russell? Oh, right. That's Russell Phagan. That's, yeah. So anyway, I guess we'll wrap it up here because I'm just going to get into like angry ranting. I've opened up my my beer at this point just because this is so frustrating. But yeah, and I see somebody noting they use systems like that in Chicago to figure out where gunshots are coming from. Yeah, I just don't know if that's a business that KE Arms wants to get into per se. Maybe not. Sometimes when you win lawsuits, you can end up with stuff you don't necessarily know what you want to do with. Like if you sue a particular homeowner, it's like, great, now I have their truck. And I don't really want their truck. I want money, but the truck is all I can claim. So yeah. Somebody saying, does GWACS stand for something? I don't know, and ultimately, I can't say I care. They're much more fun to make fun of. So, and they make it so easy. Anyone who wants to help buy KE stuff or IFAX. So yeah. So I don't have a link handy. I really should, but I'll sort of tweet one out later. But yeah, somebody says, is Ian drinking Lucky? Yes. You know what? Lucky is a great beer for, it punches well above its cost. So
is that damning with faint praise there?
A little bit. There are much better beers on the market. I buy Lucky in part because I like it for doing leather work. It's the kind of beer that is good enough that you don't mind sipping on it while you're doing something else, but not so good that you want to have like 4 and start screwing up your leather work. So, yeah. Off topic, but when will we see the two of you at the same brutality match? That's tough because you're like on another continent, aren't you?
Yeah, and I can't. The original plan was to make Desert Brutality in November, but I can't. I've too many.
I can't make
here.
I pulled a bunch of hunting tags, and I'm gonna make sure I try to get out there and try to fill those because I would really like an elk. Elk are made of delicious, and so yeah. And I see somebody saying, where are IFACs being sold that support KE? I don't actually know, but yeah. And I guess the other thing I will sort of push, I see my mod Against the Tide, who is Love Against the Tide, very dedicated there, but pointing at my Rule of Law channel. But the thing I'm going to sort of push here is I'm also doing fundraising for Extra Life. And so you can see that it's the pinned tweet on my Twitter feed. And basically, I'm just trying to raise money that's going to go to the Stollery Children's Hospital. So sick kids, I think, is a good cause. So I'm very happy to try to push that as if you've enjoyed this and you want to sort of throw some money at the channel right now, throw it at that Extra Life fundraiser. Because, I'm a lawyer in my day job. I kind of want to see about giving some stuff back if I can. So, yeah, I did that last year, and I'm doing it again this year. So, all right, let's wrap this up. I'll wish everyone a good day, and hopefully this has provided a little bit more insight into what's going on this one. And yeah, I wish I could say there was more to it, but yeah. Anyway, see you folks.
Bye.